Item 1.
Supplementary list, item number 1, fresh admission.
Lordship, transfer of the TR.
Yes.
Transfer of TR case number 69 of 2023,
Yes.
which is pending in the Court of Law, additional session judge, come fast track court, POSCO, second, Bhubaneswar to the Law and Court, additional session judge, come fast track court of POSCO, one Bhubaneswar, your lordships. The accused person has been charge sheeted.
You want to be, you want it to be transferred from POSCO 2 to POSCO 1.
2 to 1.
So move before the district judge.
Your lordship, he is not.
He is not?
Accepted this application. Sir.
Why? Why? Why?
Why?
Why? And on what ground do you want transfer?
Ground, your lordships. The accused person has been charge sheeted under section 363, 366, 376.
Yeah, that's all right. But why do you want it to be transferred?
POSCO 6, POSCO.
Para 5 might have kindly see that para 5 he has made allegation against the PO.
Your lordships. And the conducting councils of the informant, your lordships, has filed an affidavit, annexure 2, your lordships, page 19 to 20.
Wait, come to paragraph 5. That is something that 3 witnesses who have already been examined inside the chamber, not in the dock. These cases are.
Your lordship is not allowed to enter into the conducting council.
Witnesses to support the accused settlement and influence the witnesses to obey his order. Even these are all vague allegations. Why are you making those allegations against judicial officer?
Your lordship, for which the senior counsel, Mr. Biran Shirai, who has filed an affidavit, annexure 2, your lordships, specifically your lordships. Annexure 2, your lordships.
No, you are making very serious allegation against a judicial officer that he has been gained over by the accused.
Your lordship is not allowed to.
I will dismiss it with heavy cost. I'll dismiss it with heavy cost. You better withdraw this application. Otherwise, you know what will happen if I will direct an inquiry and in the inquiry it is found that this affidavit is false, because you can never prove this. You can never prove this. Now, why are you making this allegation against a judicial officer? What does he have to do with a particular case?
Your lordship, the AG is not allowed to conduct this case, observe this, the protection to the victim girl, your lordships, and other witnesses, your lordship.
No, who are you? You are the informant.
Informant.
So what is your grievance? He conducted the evidence in his chamber. These matters are always held, as you say, the in-camera trial. The statute also provides that these cases are to be heard in camera. So, what is wrong in it?
Your lordship is not allowed to.
Not allowed to what?
Not protect the petitioner, the victim girl, or on behalf of the 3 witnesses, your lordship, who has already been examined, your lordships.
No. You have said that he has taken bribe from the accused person.
He has stated, your lordships, he has stated.
No, this on this you means you're the whoever has shown this affidavit. How? The very serious allegation you are making against a senior judicial officer. He's in the cadre of district judge. You are saying that is taking bribe from the accused persons to suppress the evidence. You substantiate this. Please substantiate this.
Yes, stated.
No. You have to substantiate this. Let there be an inquiry. You face the inquiry. You cannot. This cannot be tolerated.
In the meanwhile, 3 witnesses have already been examined, your lordships.
You see, if there is any procedural irregularity, you can always challenge it in the higher judicial forum. Why make such allegations?
And my lord, that the conducting council has filed an affidavit.
Yes, that is what I'm saying. He has made very serious allegations.
He is the informant of the.
The role of the informant is first of all very limited.
Yes, sir.
As per section 304. CRPC. 302 or 304. I think 302. What is the role of the informant? He can only support the public prosecutor and he can file a written statement. That's all. At the end of the trial, he can do that.
He did not allow to enter into the Champering, your lordships.
Yes. Any magistrate inquiry into
To assist only.
yes. If any such 301 actually. Any person will remain there under the direction of the public prosecutor or stand public prosecutor and may, with the permission of the court, submit written arguments after the evidence is closed in the case. So this provision is there. You can always invoke that provision by filing a petition that I may be permitted to assist the prosecution under section 3 as provided under section 301. So why make these allegations? It is up to you. I leave it to you. If you if you are pressing this application, then it will follow its natural consequences. You have said that is not tolerable. The behavior is not tolerable. That is one part. What kind of behavior you have not said? And taking bribe from the accused persons. Making such wild allegations, taking bribe money.
He has stated that I know, your lordships.
That's all right. You, it's not you personally. I'm saying whoever has filed this affidavit, taking bribe means.
He has stated the gain of.
Kepe nele, ketana nele, kou form nele, kepe nele. Lekhi na the. Kete tongka bribe nele, se kotha lekhi na the. Kou mode nele, electronic mode transfer hala, ki cash nele, ki check nele. Lekha hala ne. Nama judicial officer to sosta puri chinde kya? Just to make an allegation. Very unfortunate. Will you withdraw or I will permitted to withdraw? Otherwise, I would have imposed heavy cost and and I will refer this matter to the Bar Council of Odisha. I will refer this matter to the Bar Council of Odisha. Just one opportunity I am granting you. If you want to withdraw, no adverse order will be passed. Simply. I leave it to you, Mr. Bhatt. I leave it. I am not forcing you. But I have made my mind very clear. I am going to refer this matter to the Bar Council. If you press it, I am not going to refer. Whoever he may be a senior counsel, whatever. He is also an officer of the court. Just read paragraph 4. Just read paragraph 4 of the affidavit. That such type of attitude and behavior. What type? Misbehave. Kaun koile? What are the words? Kaun bhasha koile? कौन खराब व्यवहार कले
से कोई हबने खराब भाषा नो कि तो जोटा होची नॉट
काई से लिखि थाते से क्रिमिनल साइट रे लिखियो पड़े बोली जानते क्रिमिनल साइट रे अपन जदर केस करछु यू हैव टू राइट द एंटायर थिंग
he is also criminal lawyer so
he is a criminal lawyer, he doesn't know it and he is not tolerable and taking bribe when the accused persons ये ताले आउ आज्ञा ये चलिबो किमते आज्ञा जुडिशियरी चलिबो किमते yes what do you say permitted to withdraw.
I don't know, 2.
Yes.
In this case, my lord, I have filed in one miscase for change the nomenclature. Nomenclature TRP-CRL instead of TRP-C.
There is no miscase here. Acha. I 52 of 2024. Considering the submissions, the prayer for change of nomenclature is allowed. The case be registered as TRP-CRL instead of TRP-C. Yes, what is this case? You wanted to be transferred? Pending before the concerned court at Barampur to either Bhubaneswar or Pulbani. Why? Where is the lady staying?
In this case, OP has filed another TRP. That may be tag along TRP-C 158 by 2020.
Oh, let's this matter next week along with TRPC number
158.
158 of 2024.
23.
All right.
I don't know, 3.
My pleasure, Lordship. Your Lordship already issued notice in this case.
Already issued?
Yes, my lord. On 9/4, my lord. And I have served copy to the state as well as Mr. BP Tripathi,
Yes.
who usually appears on behalf of the health mission director.
Yes.
And he is not yet appeared.
In fact, my lord, this is an order which has been passed by the director in RHM. So, my lord,
Deregulation
he is to represent him. Opposite part number 2, Mr. BP Tripathi.
Please
I'll
send a message. I'm just passing it over.
Yes.
Pass over.
I don't know, 4.
Pass over.
I don't know, 5.
Many leaderships. But the present case is relating to the appointment of the PT.
May I please, your lords? Lordship, Senior Counsel Mr. Rudra Prasad Kaur is engaged in another court. Can you pass over this matter?
My lords, I pray let it be passed over. But difficulty is my lords are directed to submit the resolution books. Yesterday I have got it. And the principal has faced an accident and met in bed. And he has also retired. Anyhow, I have got the principal.
Well, so I will pass it over, let him come.
Let it come up to 1 week because I shall go through the records. So I have brought records today here.
No. It is a 2009 matter. Mr. Rudra Prasad Kaur.
Yes.
My lords, I have
Let him come, sir. Let him come.
tomorrow. Let it go tomorrow.
No.
I shall go through it. I shall go through it. The records I have got it.
No. Let him come.
Anyhow, my lords, if my lords shall pass over, I'll let it pass.
Just.
Yeah,
pass over, let him go.
All right.
I do not 6.
Pass over.
Please. My Lord, on the last date on 16th April, my Lord had heard it in part. If my Lord recollects.
As regards the status of representation submitted by the petitioner on 15/1/2020. Yes, Mr. Rautray?
My lord,
What?
I have exercised my limited power in respect to my lord's order. Now I have filing a letter and I have already solved a copy. Thank you.
You have received it?
Yes. Received.
So the college is not appearing.
In spite of receipt of this letter, the college is not appearing, man.
In view of this, it is easy to dispose of the case.
But that petition will not get any relief.
Yes. That is what I am more interested in.
Practically,
It is not, there's no fun in passing a paper decree. It must be enforceable and the petitioner must get the due.
My lord.
You have done your job. You have also threatened the institution of de-affiliation.
But now that insurance became deemed university, my lord. And he is our beyond control.
Now it has become. But you have said this?
We have said as a threat, my lord, so that he can appear before my lord.
But if it itself is a deemed university, how is it under you? It is no longer under you.
It was under us.
It was. But now you have said that it will be constrained to de-affiliate the courts, including non-grant of affiliation. And another thing is that now you say very conveniently say that 15/1/2013 representation is not traceable. Where will this person go?
That representation actually not traceable. And on my advice, this letter given to.
That's all right. I appreciate it. But then how to grant him relief? What is this Krutika Institute of Technical Education?
Bhubaneswar.
Lord, in 22-23, my lords had on an early occasion, there was doubt regarding the existence. So I had filed a memo with documents. And in 22-23, it was affiliated. So in 23 only, it appears to have been become a deemed university. And the memo also.
If it is a deemed university, then you will have to amend your writ application.
My lord, the principal prayer and obligation is with the OP number 2, the trust, which has also filed the counter. So there is no change in the constitution.
No. If the status has undergone a change in the sense that it is no longer a college affiliated to BPUT, but a deemed university, that is totally different.
That is correct, my lord. But when the cause of
it is up to you whether you need to amend your writ application.
I would do that amendment.
You do that, then we will consider, then we will send notice again if he doesn't appear.
My lord, then only because delay in issuance of notice to BPUT, as well notice issued in the month of November 2023, my lord. By that time, that insurance.
Anyway, you have entered appearance. You have.
I have entered appearance. I have filed my counter.
You do one thing. Sri Rautrai, N.R. Rautrai, Learned Counsel for the
Opposite panel three, ma'am.
BPUT, produces a letter dated 19/4/2024 addressed to the principal of Krutika Institute of Technical Education, requesting him to redress the grievance of the petitioner on the threat of de-affiliation of the course, including non-grant of affiliation and de-recognition of the college. However, in course of hearing, it is stated at the bar that the status of the institution has undergone a change in as much as it is now a deemed university. Learned counsel for the petitioner requests for an adjournment in order to file an application to amend his writ application to implead the deemed university as a party. List this matter vacation पर आसियो. List this matter vacation पर. On 25th June, application for amendment, if any, be filed in the meantime. Be kept on record. ये जो लिखे हैं नीचे N.R. Rautrai produces a copy of the same be kept on record. Yes.
Item 7.
In item 7, my lord directed the government to serve a copy of the government letter addressed to the additional government advocate, which I received now. That is the letter supporting to the stand of OUT that the petitioner is not entitled because he cannot change his stand. Once getting, he actually belongs to SC, but got the appointment under the category of ST and availed the promotion under ST. Subsequently, when he wanted to get promotion early, he changed his stand that I belong to SC. The inquiry was held up. Law department was consulted through the government, and the government has given a detailed short virtually to the points in issue. And that letter last time my friend has given to the Hon'Ble Court, and my lord said that copy be solved. And now I just received the copy.
Anyway, let us hear the matter. Let us hear the matter. Yes, Mr. Rai, your matter.
Madam.
Yes.
There, my lord, it is no more case that I had at any point of time I have claimed that I belong to ST category or produced any ST category certificate, nothing. From the very
But the post was reserved for ST.
ST category.
Yes.
But at that time, under what circumstances I was appointed against ST category, that can be only revealed by production of the relevant recruitment file by the university. So I had no knowledge, my lord. So at that, in view of the section 6 of the ORV Act, interchange is permissible. That if it is not available, then they could have appointed.
So the rider is the bottom line is ST candidates must not be available. Then only it can be interchanged.
If now I have not seen no access to the neither the file or merit list, nothing. Now from this letter it says that ST candidates were available.
Yes.
So under what circumstances I have never said that I belong to ST category. So I belong to SC category. I produced my certificate, which I subsequently verified that the genuine. So under what circumstances I was appointed against ST category, that can be only explained by the university by production of the relevant file matter.
If
now,
they don't produce, it is up to them. Why should this court ask for that?
The fag end of my service just before retirement, what prompted the university to move to the government obtain clarification, only to deprive me from my some financial benefits I am entitled to get. Even if they consider me that I belong to general category, no such order till date has been passed. Only that the interdepartmental communication what they have received, nothing has been communicated. Now, even if they consider me them a general category, in 2011, when this post of assistant registrar became vacant, I was the only candidate who was eligible in that zone of consideration for promotion. They could have done it. Now they considered me waited for me. Applying the catch-up principle, they got some other persons promoted to the post. Then they appointed them against the general post and said in the representation, you will see in the last disposal order, importance order, that 2015 when he will retire, you will join. Now my limited payer is their own admission. You will kind of have a glance. That OUT, my earlier representation while disposing it of.
Let us read this letter. This letter contains all the facts.
My lord.
This letter,
My-
yeah, tick. Mr. Mishra, please. So this contains all the facts,
My lord,
isn't it?
My-
Please, can you please place this letter?
my lord. The additional government advocates so and so WPC number file.
No, we can come to the second paragraph,
For the available.
third paragraph, as per the available
As per the available records, the petitioner Sri Somnath Mandal belong to ST category by birth.
SC category.
SC category.
Yes.
Sorry. SC category by birth, which had been verified by the Tahsildar Remuna Baleswar. He had submitted SC caste certificate at the time of recruitment of the post of junior assistant before the OUT authorities. But
So
he
this
was-
is significant. He has
My-
submitted SC caste
SC
certificate.
caste.
All. Then
But he was selected by the university authorities under ST category and joined as such in OUT by the office order number so and so dated 6/2086.
yes,
As reported by the OUT, the case of the Sri Mandal would not have been considered at the time of recruitment as junior assistant in SC category, since he had secured much less mark than cut-off mark in this category. But he was illegally recruited under ST category, though ST category candidates were available. The petitioner did not object to his caste status soon after receipt of the appointment letter. Instead, he joined in the ST category as junior assistant. While accepting first promotion to the rank of senior assistant during the year 1990 by the OUT office order number 1788 dated 29/1/1990 under ST category, Sri Mandal did not raise the issue in his caste. Subsequently, during the promotion to the rank of section officer level 2, he raised the issue of his category as SC and claimed the seniority over another SC candidate and got promotion. Again, he got promotion to the rank of section officer level 1 under SC category by the OUT office order number so and so 19/2009. In view of the ensuing DPC for the post of assistant registrar in OUT above, the OUT sought clarification from this department as to whether Sri Mandal can be promoted to one post of assistant registrar cum accounts officer from the rank of section officer level 1, though DPC, as he comes under the zone of consideration for the said post when his initial appointment and past promotion being illegal since 30 years back. In this context, as per the views of law department, this department has clarified the OUT that as section 6 of the reservation of vacancies in post and services for SC/ST Act 1975 stipulates that the reserved vacancies in the appointment shall be exchanged between scheduled caste and scheduled tribes only in the event of non-availability of the candidates from the respective communities. The appointment of Sri Somnath Mandal, an SC candidate in this case against an ST vacancy, notwithstanding ST candidates were available at the time, was obviously in the violation of the above procedure, and his appointment was therefore illegal. His subsequent promotion against ST vacancy is also an illegality. However, Sri Mandal, having not himself contributed to such illegality, and his service against such post having been availed by his employer, his appointment to such post now cannot be called in question. But at the same time, keeping in view the interest of the ST candidates who lost their post, the department should have regularized the gradation list in subsequent stage by assigning Sri Mandal's position among the unreserved appointees. That having not been done, the position of Sri Mandal now in the select list cannot be set as right position, and DPC cannot be held basing on the present list. Hence, necessary steps may be taken to revise the list accordingly, assigning Sri Mandal his position as he deserves and decides if he is entitled to promotion as per the revised list. Consequent upon the above view in the matter, OUT again sought clarification on whether the gradation list would be revised from the first promotion of Sri Mandal, that is from the level of senior assistant, or be revised from the date when it came to the notice of the authority. After obtaining considered view, the law department OUT clarified by this, since Mandal has so far already upheld the promotion, he being rightly or wrongly placed in the higher position in the list, any correction of the earlier gradation list now may not be of any consequences. So now only in order to regularize the matter for the purpose of ensuing promotion, gradation list may be prepared, assigning him his right place in the list. So in this context, it may be submitted that department was neither involved in the above case.
Yes, yes.
So my lord, the appointment of the petitioner in the ST category, I have no role in it. They appointed me, and from the very beginning, it's not a fact that I have not raised the objection that I belong to STC category. I may be, my list may be, I may be placed in the SC category gradation list. But
Where is that? What is those? This is the advertisement is of 2009 against which you had appeared.
86.
A 2009 advertisement account, Annex 12 series. So something else. Anyway, you were appointed in 1986.
86.
Then you say that you have objected or you have brought it to the notice of the authorities that you should be placed in the SC
Yes,
category.
category.
Where is that? Do you have any letter?
Let's write there, madam. Annexure 7th series, my lord. Page 25 it start.
Explain to me, Lord, for a second.
Yes.
I'm not interfering. With permission, if my lord will ultimately my lord will take a decision with the writ petition so far the prayers are concerned. I think the prayers, all the prayers have become infructuous. May I just draw kind attention of Hon'Ble Court to the prayer first.
Yes.
If he succeeds in any of the prayer, then he has some value addressing and taking time of all these categories for taking whether he is entitled to or not. Now, admitted he has been retired. And after retirement, he has not made any amendment to the prayer that post-retirement benefit or post-regularization, all these things are not there in the prayer. Whatever it was long before his retirement. Now, the prayer portion is like this, my lord. May kindly quash the order, Annexure 11. Annexure 11 is at page 33. In 33, a decision was communicated to him saying that one Madhusudan Behera has already been observed as the assistant registrar for the scheduled caste category. There is no post vacant. Now, Madhusudan Behera is not a party to this case. So, against whom he has come up, he is not a made a party. And in the meantime, Madhusudan Behera has been retired and this petitioner has also retired. So that with this letter, quashing of Annexure 11 does not arise at all.
Yes. Then
that is the first prayer. The second prayer is that the writ of mandamus appropriate writ be issued, commanding opposite parties, more particularly opposite party 2 to modify, cancel letter number 7813. It has already time has already been elapsed, so that nothing to be recovered from that prayer also. The prayer D is I may be directed to be promoted. So all these three prayers, if at all stands, then virtually he has no case because it has become infructuous. Unless it is modified or with a subsequent prayer that post-retirement regularization or post-retirement promotion, unless that comes or that prayer, court cannot grant relief voluntarily. No, he can't take benefit.
Obviously. Yes, Mr. Rai, how do you respond?
My lord, my prayer was to grant me promotion from 2011.
Where is
When
that
I
prayer?
came to the zone of consideration, I was the only eligible candidate to be promoted to that post.
Yes.
That prayer is still there. Now there, the annexure, page 33 that is referred to my senior, it is their own admission that Madhusudan Behera is there, post is not vacant. As soon as he retires, you will be promoted to that post. My limited prayer is now since all of them, the private opposite parties have retired, now I am confining my prayer to that portion only. Your own admission, you have university has said that as soon as Madhusudan Behera retires, you will be promoted to that post. Now that much of relief I am claiming without.
When did Madhusudan Behera retire?
2015, that is the letter that,
During pendency of this writ application.
my lord.
So you should have amended it. You should have amended and modified your prayer accordingly. As it stands now, as Mr. Ponda has raised, it is a valid point. The court cannot grant you relief. Even if the court wants to grant you relief, the court cannot in view of the prayer. Think it over, think it over.
I will
File further arguments in part, let's this matter next week.
Ne-
I'm just allowing him time. Let him think it over.
Right.
If he decides to amend, well and good. If he doesn't, yes,
I don't know the age. May I be pardoned, my lord?
yes,
Your lordship have passed over a matter, item number 3.
yes.
My name has not been reflected in the, I have filed my wakalatnama. My name has not been reflected in the cause list country.
So you will take it up next week then.
But that's the only prayer.
All right.
Yes. Interview order only.
List this matter next week, indicating the name of Sri BP Tripathi in the cause list, who appears for the opposite party. Item 3, interim order to continue.
Deeply grateful.
Item 8.
Item number 8.
Please, your lordship. My lord, your lordship, last occasion, the matter is hard on part. My lord, here in this case, the present petitioner is working as a Gana Sikhyaka
Yes,
since the year 2009, 2008 to 2013. And after that, there is a
as before.
Fine.
Shall not be questioned why the petition shall not be re-engaged as Gana Sikhyaka as before after acquittal from the criminal charges. Yes,
my lord. In that light, my lord, your lordship told me that to go through the decisions that I am relying upon, and I go through some decisions and I am placing it.
yes,
My lord, I'm going through the 4 decisions, 2 of Honorable Apex Court and 1 of the coordinate bench of this court and another of my lordship's order, my lord. The first that one Ramlal versus State of Rajasthan, my lord.
Ramlal versus State of Rajasthan, yes.
My lord, in that case, there is the person is working as a constable in the Rajasthan Armed Constabulary in the 9th Battalion, my lord. He is working there, but basing upon a affair, that is, he is charged for the offense 420, 467, 468, and 471, my lord. And after that, there is simultaneously one departmental inquiry is also occurred. And my lord, considering that the 2 procedures are simultaneously going on, that the same persons are in the charge-sheeted witness, that they are the 5 witnesses are examined in the departmental proceeding. These 5 witnesses are also examined in the criminal trial. So my lord, considering the same, the person is acquitted from the criminal charges. That is on the para 6, my lord. Para 6. The person is acquitted.
Acquitted the appellant. Where is the final?
My lord, the final. I am relying on the para 25, 26.
What is the effect of the acquittal ordered by the appellate judge in the criminal trial on the
There is
dismissal
2
passed to you?
questions created by the Honorable Apex Court that I am relying on the para 25. The expressions like benefit of.
Just.
My-
Yes.
My lord.
Yes.
My lord. My lord, in para 25, it is stated that the expressions like benefit of doubt and honorably acute used in judgment are not to be understood as magic incarnations.
Incantations. Incarnations, no incantations.
Incantations. A court of law will not be carried away by the mere use of such terminology. In the present case, the appellate judge has recorded that the exhibit P3, the original mark sheet, carries the date of birth as 21/4/1972, and the same has also been proved by the witness examined on behalf of the prosecution. The conclusion that the acquittal in the criminal proceeding was after full consideration of the prosecution evidence, and that the prosecution miserably failed to prove the charge, can only be arrived after a reading of the judgment in its entirety. The court in judicial review is obliged to examine the substance of the judgment and not go by the form of expressions used. And in para 26, we are satisfied that the findings of the appellate judge in the criminal case clearly indicates that the charge against the appellant was not just not proved. In fact, the charge even stood disproved by the very prosecution evidence. As held by this court, a fact is said to be disproved when, after considering the matter before it, the court either believes that it does not exist or consider its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the suppositions that it does not exist. A fact is said to be not proved when it is neither proved nor not disproved. And my lord, in the para 27, we are additionally satisfied that in the teeth
So what is the point of law?
my lord, there is two proceedings cannot go on simultaneously if that is on a same similar footing, that the criminal charges is on a same and the proceedings
Yes.
and the departmental proceedings on the similar footing, that is cannot go on simultaneously.
Yes.
That is the first part, my lord. And when there is the person is acquitted, when the prosecution is miserably failed, that is no point that the honorary acquittal or something that is which is stated from the para 25, that the benefit of doubt and the honorably acquittal used in the judgment are not be understood as.
You have to show
Madam.
that first of all, the charge in the criminal case and in the disciplinary proceeding was the same, was identical.
Madam.
Secondly, the witnesses examined in the criminal case to prove the charge were the same witnesses called upon to prove the domestic inquiry in the disciplinary inquiry. So let us go to the facts now.
Madam.
Then only, unless there is a wholesale identity, it is not possible to show that only because he has been acquitted in a criminal charge, the disciplinary proceeding should also be dropped. There is no such.
Madam, from the first.
That's no. There was no disciplinary proceeding against.
No,
him.
my lord.
Say that.
My lord, the person is engaged as Ganasikyapa, which is in Annexure 1. That is the engagement letter of the present petitioner, my lord, in which there is in
Yes, Mr. Patnaik.
Yes.
Annexure 2 is the impute order probably.
Yes.
Mr. Deepak Das, J. So and so is hereby disengaged from his contractual engagement.
Yes.
On the ground that it's a contractual appointment, so probably no notice show cause was given.
Yes.
Any show cause was given.
Our records do not say so.
Yeah, so that becomes bad in law. Principles of natural justice have not been followed, even if he is a contractual employee. That is what I've held in this Abhimanyu.
Yes, ma'am.
Abhimanyu Malik's case, which she has given. The matter was slightly different. There only because he was involved in a criminal case, they had disengaged him. I said mere involvement will not amount to, conviction.
May I pray, my lord, this matter can it be, my lord, taken up next week? Because, my lord, I am just having a file, my lord, where the annexure 2 is not there. The copy of the region is also not available with me, my lord. You know? So, my lord,
What happened is, he was arrested. He was arrested and he was detained in jail custody for 48 hours.
Yes.
On that ground alone, they disengaged him.
Yes, ma'am.
And that was in 2013. Now, the thing is what...
he didn't challenge the same, my lord.
He challenged it, immediately challenged it.
He didn't challenge the same. Thereafter, my lord, the criminal case was, in the criminal case, he was acquitted. After that, my lord, he made a representation before the authority, the grievance petition. That grievance petition was rejected. Challenging that rejection order, my lord, along with annexure 2, my lord, he has after the
See what can be done.
Yes.
See. The principle of natural justice was not followed, and secondly, on merits also, he has been acquitted by the criminal court. What remains?
Merit rate. Compromise.
Compromise? 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 Is it a compoundable offense or what? See, लिखी थी वैसे भूले लिखी थी वो कौन करेगा?
Charge election.
See, लिखी दी थी ना compromise कोनो compromise. I am convinced that the prosecution has miserably failed to bring home the charges under section 341 and 354A.
Yes. But prior to that matter,
इस कोई लिख दी थी, तार माने किसी ने. There is no such thing as compromise in a sessions case. Non-compoundable case, there can be no compromise. See, लिखी दी थी. And he is a very reputed district judge. I don't know how he could write it. Very knowledgeable and he is in fact called upon to act as resource persons in the judicial academy. Very respected, very senior, he was a very knowledgeable person. But but anyway, the final finding is that the prosecution could not prove the charges. So he was acquitted. There is no question of any disciplinary proceeding against him. He was not even given a show cause. Set it aside.
your lordship, it was held in the case of Abhimanyu Malik. There, your lordship came to a different conclusion. That because his name was already included in that regularized list, so in terms of that contractual rule of 2013, because OCSCC rule has its application, that
He will be, even if this court directs reinstatement, it will be notional. First of all, notionally, only for the purpose, whatever benefit is there, whatever benefit can be granted to him. No, you want an adjournment?
only next
Tomorrow.
During the
Tomorrow.
next week. This.
Tomorrow is
Tomorrow.
Tomorrow is as heard in part, as requested by Leonard's State Council. Let's just matter tomorrow.
I don't know, 9.
And this became a lifeline litigation for the petitioner.
Yes.
Therefore, my anxiety level is something increasing. Where a person engaged in Balwadi worker.
No, then you don't place the case today. No. Arey, Mr. Das, you don't understand. As a lawyer, you have to be free from all emotions.
If you practice well,
No, if you wait, let the court is saying, please wait.
Sir.
If you openly admit that you are suffering from anxiety, then you will never be able to do justice to your client. You rest nahi jaye to kali kariye.
No, my lord. In fact, my expression was, it's a usual practice when you are arguing rich man's cases, we are comfortable. But when you are arguing cases which became a lifeline for the petitioner, therefore, my anxiety. That was my.
But you said that
that was my intention.
Anxiety is
That was my intention.
My friend,
Because-
I am for the other side in this case, which lordship's kind permission. My friend is anxious because of this case.
No, it became a lifeline litigation for the
Because
petitioner.
I remember just few days back, a client appeared in person before Honorable Justice A.K. Mahapatra. And he said, crying that I am an old man, please save me. Honorable Judge, in fact, said, observe that I am not going to decide the case on your emotions. I will decide it in accordance with.
Yes. That is what I'm saying.
Yes.
Yes, what has happened?
But a Balwadi worker, after closure of Balwadi center, was engaged as Anganwadi worker. Her selection was challenged by my learned senior's client, OP5. Let's say kindly have a glance to the order passed by the ADM at page 43. The 2 points which I want to, before my lord enter into the impugned order, one part is which has completely ignored. A person practicing fraud, that part has completely ignored. The appellant in the Anganwadi appeal case, OP5. Because she has suppressed many things, manipulated, that part has not been discussed. One part. Your lordship know the person of law, a person approaching clean hand is not entitled to get in leave. That is, I have some citations. Point number 2 is the rule of game. Advertisement has been misinterpreted. In the advertisement, there is a wrong committed by the advertising authority, But I should have been granted the benefit of that because the rule of game cannot be changed after the game is commenced. Your lordship, before I start.
আমার পিএন মানে কি হচ্ছে সেটা বুঝছি কথা এত বড় পার্টি কথা করছেন মাইন্ডটা ডিস্টার্ব হয়ে যাচ্ছে
So that too, point of law, pure question of law, I will cite. Thereafter, your lordship kindly have a glance to before the impugned order, page 9. What
Page
was
9.
the page 9 is the advertisement.
Yes.
Clause number 2.
Clause number 2.
Clause 2, sir.
Yes.
Annex 1 clause. প্রার্থিনী সম্পৃক্ত অঙ্গনওয়াড়ি কেন্দ্র অঞ্চলের বাসিন্দা বলি
স্থায়ী বাসিন্দা
বলি বাসিন্দা পত্র
স্থায়ী বাসিন্দা বলি সম্পৃক্ত তহସିଲଦାରଙ୍କ ଠାରୁ ପ୍ରାପ୍ତ ହୋଇ ସ୍ଥାୟୀ ବାସିନ୍ଦା ପତ୍ର ପ୍ରମାଣପତ୍ର
ସାର୍ ସେଇଠି ଅଛି 2016 ମସିହାରେ ଦାଖଲ କରିବ I am putting emphasis 2016 ମସିହାରେ it may be a mistake I will then I proceed to the impugned order. So my submission would be by end of 31st of December, I should have been given opportunity to submit my residential certificate. That in fact that was done after 1-2 days. And she was working all along as a Balwadi worker since 2004. That was the admitted case. Now, Lordship, kindly see page 43. 2004, she was working after closure of that center, Anganwadi converted to Anganwadi. Thereafter, she was engaged. And there's a guideline. If my lord kind enough to see that guideline first, thereafter better. In the page 68, in the counter, they have, while I am obliged to the Council for the State, they have annexed that. Page 68.
25/2007.
My lord, the 21/8/2009. Page running page 68, my lord.
Okay. Okay.
And there is one difficulty. The state has filed a counter, my lord, in order to assist your lordship properly. I should have a copy of it.
Yes, you will have a copy.
Let me please.
I'll assist on the writ petition itself
Yes.
also.
Yes.
So this is in the nature of.
We will ask the State Council to grant you a copy.
Sir, in parts, lordship, running page 68, the clause number, there are two clauses relating to Balwadi workers. A Balwadi worker can be engaged as Anganwadi worker provided that she has worked as Balwadi worker in that particular village. My case is that I was working on the same ward number 7, same. A Balwadi worker not having matriculation can be engaged as Anganwadi worker based on undertaking. I put emphasis, undertaking that she will pass the matriculation within 3 years. So my point is, undertakings are acceptable from the Balwadi workers. Now, my lord, kindly turn to the impugned order. Page 43. This appeal is directed against this short order. This appeal is directed.
Next paragraph. Next paragraph.
Sir, next one. The case of the appellant in brief is that respondent number 2 published an advertisement by notification such as inviting application for interested candidate for filling up the Anganwadi worker in respect of ward number 7, Noyagarh. The last date for submission of application 29/16. It was specified in the said advertisement that the candidate must file attested copies of the required documents, residence certificate, proof, such and such. It was further specified therein that no undertaking for production of document will be entertained and candidate would be rejected. In response to such notification, 4 candidates, including the appellant and respondent 1, has applied. The respondent number 1 not submitted residence certificate along with her application. The selection committee was convinced on 4/10/2016 and respondent number 1 was selected and Anganwadi worker in respect of ward number 7. The contention of the land advocate for the appellant is that the respondent number 1 is the residence of the village Angisingi, village under Saranakodu PS. She has her name in the voter list in that village. This petitioner is arguing, presenting his case in person. That was also there, paragraph 1. And appellant engaged, OP5 engaged advocate. The inquiry report next page reveals that she is permanent resident of village Angi. It is further submitted by him that residence certificate bearing miscase number such and such production of respondent number 1 was issued by Tahsildar on 15/9. Last date for submission application 2/9. The respondent number 2 has applied for the certificate on 3/9. It is clearly established that the application for Anganwadi worker submitted the respondent 1 before respondent 2 was not accompanied by the respondent certificate as per the terms of advertisement. Such application should have been rejected. The CDPO Noyagarh, instead of rejecting the application, has illegally entertained the same and misguiding the selection committee for selection of 1 AW worker. Ward number 7. As a result, the appellant was deprived of being selected Anganwadi worker for the aforesaid Anganwadi center. His prayer is that, therefore, to declare the selection of appointment respondent 1 as Anganwadi worker for the ward number 7 as null and void, to direct the respondent 2 to appoint the appellant as the next paragraph is what was the case of the petition. The contention of respondent 2 is that she has been residing in ward number 7 of Noyagarh NSC since last 10 years. She has been residing in the ward number 7 since last 10 years. And considering her stay, the Tahsildar Noyagarh has issued residence certificate in her favor. The residence certificate has not been challenged in appropriate court of law. Such issue cannot be raised in appeal. It is further submitted by her that the selection process was fair and judicious as respondent 1 secured higher mark. The selection committee unanimously selected her Anganwadi worker, ward number 7. There was no question, any arbitrary action on part of the selection committee. Having had both the parties to the dispute and going through the evidence and record, I am of the opinion that respondent 1 has been residing in ward number 7, Noagarh, NAC for more than 10 years, as it is revealed from RI report, wide annexure 2, submitted by the appellant. And inquiry report of the CDPO Noagarh, there is no bar against a person belonging to the village Engsing to reside in Noagarh town. Article 19 of Indian Constitution guaranteed the liberty to any Indian citizen to reside and settle in any part of the country except Jammu and Kashmir. The voter list annexure 1 submitted by the appellant is not in conclusive evidence of the residence certificate issued by Tahsildar Noagarh still holds good, having not been asseiled in appropriate form. Coming to the second question of submission of residence certificate along with the application, I am the opinion that respondent 1 had not even applied the residence certificate last date of the application, that is 2/9/16. She applied the residence certificate 3/9/16. The action of the selection committee in entertaining candidature for final selection clearly violates the condition laid down in advertisement bearing number such and such. Advertisement number is 19/8/16. In terms of advertisement, the candidature of respondent 1 should have been rejected. She failed to submit the residence certificate along with her application. In the given fact and circumstances, I have no hesitation to set aside the order of selection, respondent 1, upper ward number 7, Center Noagarh. In result, appeal is allowed and selection committee is directed to taking up the issue afresh for selection of appellant as Anganwadi worker in center. But now my submission be, Lordship.
So you have an interim order in your favor?
Yes, my lord. I am continuing.
All right.
By virtue of your lordship. May I draw my lord's attention to again to page 9. At the cost of repetition, lordship kindly have a glance. Praman Patra, Sthayi Vaisna Praman Patra, 2016 मसीहा रे दाखल करी. So it is on a bare reading of the same, it clearly indicates that within 16, but 31st December 16 is the last date. It may be my learned friend can argue that it's a typographical error, but it has to be avoided because the rule of game cannot be changed in between because the game has already commenced. Number 2 submission would be, I have filed a note of submission. Before that, let's kindly turn to the counter filed by State Council, paragraph 6 at page 50, man. Running page 50.
State or counter?
State, the state.
Running page, yes. Para 6.
Para 6. Fourth line is important. That as per clause second line, clause 8, the advertisement candidate having experience as Balwadi worker with minimum qualification shall be engaged even accepting the undertaking for production of producing HSC certificate within 3 years. In that respect, the candidate having experience of Balwadi teacher under the same ward number 7, where the Anganwadi center is situated, her case was taken into consideration. In that view of the matter, her candidature was accepted, but in appeal, that aspect was not raised by the appeal. That was the case. It was raised. Next, Lordship, kindly see next paragraph. On next paragraph is paragraph 5. It is humbly submitted on the day of verification. The petitioner submitted acknowledgement received residential certificate with the documents where the committee accept the application from since the petitioner having higher qualification, working experience, Balwadi worker, having been taken into consideration. The next paragraph, that as regard to aberrament, paragraph 6, humbly submitted the selection committee found that opposite party 5 submitted an application with incorrect information. OP5 means the present OP5, the appellant in the with incorrect information. Instead of writing her actual percentage of mark, she manipulated 55%, but actually she secured 44%, wrongly presented at the time of scrutiny. The point I was raising, the person approaching with unclean hand is not entitled to it. The next paragraph, paragraph 9, as regard to the aberrament made in paragraph 7, it is humbly submitted that the selection committee was held on dated 4/10/16 and residence certificate was available with the petitioner. what has happened, my lord, may I take a pause? Previous year certificate she has granted, she has given. Therefore, in the acknowledgement receipt, they have, in the counter also they have given that. Page 53, my lord. Page 53 in the counter. Since because the advertisement says 16, since because it was there previous years, resident certificate introduction kindly get tick mark. And it was verified by the CDPO and BDO. So in fact, that was happened because previous year certificate she has given, because she was working there in Balwadi worker. Thereafter, she again applied for the resident certificate to regularize. But the second point of my submission will be, I have given a note for your lordship's learning. I'll please. Dot. So, my lord, my first point of submission, C has manipulated OP5. So, the appellant, the appeal should have been dismissed. Point number 1. Second point is at clause number 2, that was 16 ray submit kariye. That means humble submission, my humble submission would be within the year 2016. Since the petitioner was working as a Balwadi worker, there is a conscious decision of the government. May I place my lord before my lord at page, a government decision I have also annexed, page 46, my lord. To engage this retained Balwadi worker, there is a government decision, page 46, annexure 6. The relevant, it was headed by the Honorable Minister. The last page is page 48. They have concluded. Page 47, first line says the meeting on problem of early child care education, that ECC worker, which has been reflected in the impugn order. Lordship, kindly come to the last concluding paragraph after detailed discussion. That's it. Page 40. In future, at the time of opening Anganwadi center, the retained ECC instructor would be engaged as Anganwadi worker. Now, my lords, kindly turn to the Balwadi certificate. I have annexed to my application at page.
So that is not disputed.
That
You were a Balwadi worker.
Balwadi.
So what further point you have?
But the 2 points I am raising, therefore I am citing 2 judgments that a person approaching unclean hands, that I should have indicated to my lord. What is the manipulation C has? Let's now kindly turn to her application where the manipulation was found by the selection committee. Let's kindly turn to page 27. Page 27 of the reports.
Sir, you can't raise it. Did you raise such a point before the appellate authority?
My lord, from the beginning, I just submitted my lord. She was presenting her case by her own.
No. That is no excuse.
This point.
That is no excuse. You cannot go on adding points.
No, this point.
Your point, this court in a certiorari jurisdiction will only confine itself to seeing whether the rules of procedure have been followed or not.
This point was admitted in the counter.
This court will not go into the facts, the merits of the case.
But on the face of record, what was the manipulation? For a moment. 600 mark was given.
Something which the appellate authority has not considered will not be allowed to be re-agitated before this court.
My lord, that point in fact, though she has submitted.
There are 2 points. First is whether your you did not submit a resident certificate, but you submitted an acknowledgement receipt showing application, so showing that you had applied for a grant of residence certificate, which was in fact granted in the year 2016.
The previous year, I have annexed that there was.
All right. That is the first point. Second point is that you secured more marks. That's all. That's all. Let us hear them.
The last point. No,
I've got a point.
My very first point in the case was no proper opportunity was given. Paragraph 1 I have stated because she was appearing in person. She has not been heard. This point was also raised by.
Well, she has been heard. Her contention has been recorded.
She has manipulated. That manipulation part was not reflected in the impugn order.
If it has not been reflected, it means it has never been raised. Why should this court disbelieve? Otherwise, you would have come to the court saying that, sir, I raised this point. The court did not consider it. Please remand it back. I would have remanded it.
That was my first paragraph. writ petition. It was, though manipulation was there, it is apparent.
We'll see that, we'll see that.
It is apparent.
This court cannot give a finding.
But these two-
It is for the fact finding authority to give a finding on that aspect.
Right.
Then only this court can test it in the statutory. Otherwise, will be very
These
difficult.
2 points with regard to rule of game cannot be changed. Paragraph, the clause number 2, the 2016 re dakal karibe,
Still interpretation. That requires interpretation. I'll ask the state
Right.
and then whatever
and the
the
manipulation.
private opposite party will also.
Right.
Yes, state. Though I have not allowed him to take this point of manipulation because it is not there in the impute order. You have also raised it in your counter, which I was just going through.
I'm actually representing two categories of persons, madam. One is the selection committee members. For them also, madam, I am defending. So also, madam, for the appellate authority.
Yes. Appellate authority, you don't have to, but
Because, madam, the appellate authority's view is now contrary to the decision of the selection committee. So, madam, with respect to that advertisement, Lordship may
ସେ ଗୋଟେ ଲେଖିଲା ବେଳକୁ କେମିତି ଲେଖିଦେଇଛନ୍ତି ଆଉ ପ୍ରଥମେ ସ୍ଥାୟୀ ବାସିନ୍ଦା ପ୍ରମାଣ ପତ୍ର 2016 ମସିହାରେ ଦାଖଲ କରିବେ।
କିନ୍ତୁ ତାକୁ ସେଇଟା ଯଦି ପେଜ ନମ୍ବର 10 କୁ ଯଦି ଆସି
ହୁଁ।
ସୂଚନା ଖରେ
ହୁଁ।
ସେଥିରେ ଲେଖା ହେଲା HSC matriculation pass certificate of mark list board of secondary education ଓଡ଼ିଶା ଏବଂ ଓଡ଼ିଶା ସରକାରଙ୍କ ସ୍ୱୀକୃତିପ୍ରାପ୍ତ ଅନୁଷ୍ଠାନ ବୋର୍ଡର ପ୍ରାପ୍ତ ହୋଇଥିବା ସାର୍ଟିଫିକେଟ ଏବଂ ମାର୍କ ଲିଷ୍ଟ ଶିକ୍ଷାଗତ ଯୋଗ୍ୟତାର ମାର୍କ ଲିଷ୍ଟ ଏବଂ ସାର୍ଟିଫିକେଟ ବ୍ରାକେଟରେ ସ୍ଥାୟୀ ବାସିନ୍ଦା ପ୍ରମାଣ ପତ୍ର 2016 ଜାତିଗତ ପ୍ରମାଣ
2016 ରେ ସେଟା ଇସ୍ୟୁ ହେଇଥିବା ଦରକାର।
ସେ ଏଇଟା ଯୋଉ
2016 ରେ ଶୁଣନ୍ତୁ ଆଡଭର୍ଟାଇଜମେଣ୍ଟ ଯଦି 2016 ହେଲା ଆଡଭର୍ଟାଇଜମେଣ୍ଟ ଲାଷ୍ଟ ଡେଟ୍ ପର୍ଯ୍ୟନ୍ତ ଭିତରେ ହବା ଦରକାର।
ଏଇଥିପାଇଁ ଲାଷ୍ଟ ସେଣ୍ଟେନ୍ସ ଟା ସହ ସମସ୍ତ ପ୍ରମାଣ ପତ୍ରର ବୈଧତା ଉପରେ ଏକ ସତ୍ୟପାଠ ପ୍ରାର୍ଥିନୀ ନିଜ ଦରଖାସ୍ତ ଫର୍ମ ସହ ଦାଖଲ କରିବେ। So that otherwise indicate that if both the things have to be read together, my lord, then in that case, my lord, the residency certificate is normally it is mandatory. It is to be enclosed along with the application form.
Yes.
That is the first thing. Second thing, my lord, what the selection committee, my lord, they did, taking into consideration the fact that
she was a Balwadi worker.
Yes. And for that reason, my lord, ignoring this particular certificate also, my lord, they
no, they did not ignore. They took into consideration the fact that she has already applied for a residence certificate, and she had given an acknowledgement receipt of that sub-collector or tahsildar from whom she had before whom she had applied.
Yes, sir. But and my lord, that is what, my lord, in the checklist. But if the lordship will come to the application form at page number 14 in the read petition, what the petitioner is relying upon. Documents which are enclosed, that doesn't contain any.
She did not. That is an admitted case.
What it is available in the opposite party's case, madam, that is not available. Both the documents are enclosed by the petitioner in this case. So in the checklist, my lord, which actually it has relied upon.
What you are arguing is contrary to your paragraph 7.
That is what, my lord, my situation.
So you can't do that. You have to stick to your counter on affidavit.
My lord, para number 7, my lord.
This point may be argued by Mr. Mishra, but not you. You have taken a specific stand. Since the petitioner having higher qualification and working experience as Balwadi teacher, her candidature has been taken into consideration.
That is what, my lord, I am submitting, that at the time of selection, irrespective of the fact that whether she had submitted the residential certificate or not, her case was considered and accordingly she was issued with an appointment order, and till date, my lord, she has been engaged, and till date, my lord, she is continuing as per the interim order. And what is the observation of the appellate authority, my lord? Appellate authority observed that with respect to the other parts, there is no dispute. But since there is a stipulation in the advertisement itself, and that advertisement, that application for the residential certificate, that has been submitted even by, that was not there at the time of, by the time of the last date of the submission of application, which is a document which is required to be enclosed along with the application form. So that part cannot be ignored, and that is why her case cannot be considered.
Yes.
That is the only part.
Yes, Mr. Mishra.
The selection committee considered it, but appellate authority stick to that part.
Yes, Mr. Mishra.
May I please, my lord? My lord, this advertisement, the condition that is there, which my both counsel for the petition and the state placed, I beg to submit that flows from a guideline that has been
25/2007.
Much obliged, my lord. A set of
Revised guidelines.
a set of executive instruction has been issued, and on the basis of that, the appointment of Anganwadi workers is being done. And the guideline, the advertisement is essentially a reflection of the condition that has been stipulated in the guideline itself. Now, if your lordship will kindly peruse clause 7 of the guideline, that will show why these conditions are there. Clause 7 of the guideline.
Anganwadi. Yes.
Your lordship will kindly see
Clause 7.
clause 7B. 15 days time will be given to the candidates to apply for CDPO to the CDPO along with my lord, got it, my lord?
Yes.
With the documents in support of nativity, educational qualification, caste certificate, and any other. Lordship got it, my lord.
Yes.
I give emphasis upon that nativity and other things.
Yes.
The receipt of the application shall be acknowledged by the CDPO. On the 16th day, the CDPO will verify the documents of the applicants in their presence and will notify the same.
Yes.
Because the other applicants are there.
Yes.
Then comes the objection, which your lordship was pleased to ask the counsel for the petitioner, have you objected? D. 7 days time will be given for filing of objection, if any, by my community on the issue of nativity and other things. My lord got it, ma'am.
Yes.
But this is bereft of the right of an individual to challenge, the right of the authority also to select or not to select. Now, in consonance with this, because the authority may also still refuse, even if there is no objection to an individual who is not qualified. Now your lordship will see the advertisement. That is at page 9 of the writ petition.
Yes.
And before, my lord, I proceed further in assisting your lordship, I beg to point out, this is also in the nature of a certiorari proceeding where your lordship will see whether on the basis of materials that were there before the selecting authority or for that matter after the appellate authority, the adjudication is right or wrong. And supplementation by way of annexing document to writ petition or for that matter by the state in the shape of counter affidavit will not serve unless your lordship entertains those in additional documents by way of additional evidence or whatever principle, the principle of additional evidence, unless it is a notification or other thing which is judicially noticeable. Like for example, that bar body notification is a set of executive interception which can be judicially taken note of. I cannot say that that cannot be placed here before your lordship, but any other additional document needs to be accepted, and that is possibly not the case here. Now your lordship will see page 9 that Mosia Ray Dakhal Karibe jo clause 2 re kaile, that has to be read with, as my learned friend for the state was pointing out, page 10 that khore ek jota rahila. সেটি রইলা এগুড়াক দরখাস্ত ফর্ম সহ দাখল করিবে মাই লর্ড গট ইট মানে দরখাস্ত ফর্ম সহ তারপরে সেটি তারপরে কহিলে ক্লজ 4 রে আছে ম্যাট্রিকুলেশন পাস হইଥିବା আবশ্যক ইন দি প্রিভিয়াস পেজ ক্লজ 4 রে পেজ 10 রে ক্লজ 4 রে কহিলে ক্লজ 4 নে মাই লর্ড ক্লজ 5 রে দরখাস্ত গ্রহণ করিবার শেষ তারিখ 2/9/2016 দ্যাটস ভেরি ইম্পর্টেন্ট আই উইল পয়েন্ট আউট টু ইউর লর্ডশিপ পেজ 11 মাই লর্ড অসম্পূর্ণ দরখাস্ত ক্লজ 6 কইলে আবশ্যকীয় প্রমাণ নথিবা দরখাস্ত দরখাস্ত অভাবে তৎসম্বন্ধীয় and so on দরখাস্ত ধার্য তারিখ পরে দাখল করଥିବା দরখাস্ত নাকচ করাଯିବ. Now your lordship may kindly come to the checklist page 13. The date is 3/9. My lord got it. Then your lordship may kindly see when he has applied. Page 24. তা সার্টিফিকেটটা কেবে পাইছনি 15/9/2016 এটা আপ্লাই হয়েছি 3/9 রে বুঝা কোড দেখে দউছি 3/9 রে সো এটা যদি 3/9 রে আপ্লাই হয়েছি সো therefore by the time the cut off date the very resident certificate was not available. So therefore, it was wanting. So in that sense, the learned appellate court is fully justified in holding that there was no complete application available with the authority for consideration. And my lord, I will give that authority, my lord, if your lordship permits me by tomorrow, my lord, I may be pardoned, I am not equipped with that decision. It has been held by the Honorable Apex Court as well as the Honorable Court. This time, which has been fixed by a set of executive instruction, the authority have no power to extend. There is no question of extending, so far as those timelines are concerned. Now, so far as that undertaking which my friend was pointing out with reference to the document that has been annexed to the counter is concerned, that is with respect to the qualification, namely matriculation, you can give an undertaking and file it at a later date. That is not with regard to the residence certificate which is to be filed within the timeline. Your lordship will kindly see that counter affidavit document at page page 20 of the counter affidavit, but that is subpara 3. A Balbari worker not having matriculation qualification can be engaged as Anganwadi worker based on an undertaking that she will pass matriculation examination within 3 years of her engagement. So undertaking with regard to passing out matriculation examination, not with regard to filing a residence certificate. And now, so far as these selections are concerned, it has to be strictly adhering to the guideline and in consonance, which is also the advertisement is in consonance with the guideline that has been formulated. Now, my condonation doesn't arise so far as these cases are concerned. But on the face of it, there is no question of any condonation. And saying that I have secured higher mark will only arise if there is a zone of consideration, my lord. If two persons equally placed, namely qualified, comes into picture, then obviously the person who has secured more mark will definitely have an expectation and should have a right to be selected so far as the selection process is concerned. So my humble submission is when a person doesn't come to the zone of consideration, but he cannot have a grievance and cannot say that I have higher mark, so therefore my selection is justified. And your lordship will see.
And what is your case that she does not belong to that service area?
Yes, that also I can take a aid of my lord order 41 rule 22 say that she doesn't belong to the service area.
What is 4122?
My lord, a finding which has been arrived at even against me, because here the appellate court has said that in view of the residence certificate, she belongs to the area that is to be accepted. So that finding has gone against me, but the selection has been reversed on the ground that the residence certificate was not filed, was not even born by the time the application was made. So that is the ground, and that is also a mandatory requirement. So far as that is rather, I will say, the backbone of the very guideline itself, that you should have all the documents by the time the application is made, and that is mandatory on the face of it.
No, that's a different point.
Right.
What I'm asking you is that is it your positive case that she doesn't belong to this area, but she has obtained a certificate?
But that we have said, that has been negative. That has been negative by the learned appellate court. Appellate court has said that in view of the residence certificate, she has to be considered.
No, Mr.
Man.
I need to
Man.
rephrase my question.
Man.
The advertisement as well as the guidelines say, mandate that the person must belong to this service area of that particular Anganwadi center.
Man.
Let us go to this.
Yeah, that is, I'm conscious of that.
Guideline says, from women residing in said village Anganwadi center area.
My.
So is it your case that she does not belong to that same area?
Yes.
Where does she belong to?
That's your lordship will see. That is dealt with by the learned appellate court.
Well, that is what I would like
My,
to say.
that I beg to. And he has said since the residence certificate is there, it has to be accepted. That has not been challenged. Residence certificate was obtained post back to the application.
I'm not asking about the residence certificate at all.
I have produced other documents to show that she doesn't belong to that area.
That is what
that has been brushed aside. That has been brushed aside.
That has been brushed aside by whom?
By
The order is in your favor, isn't it?
But that finding is against me.
Let us see.
Yes, that I beg to point out.
The finding is against you. You have not challenged that finding.
The finding I can. That is why I was saying order 41 rule 22.
Order what it is? Civil suit pura.
ସେଇଟା
ପୁରା civil suit
ଜଷ୍ଟ କହୁଥିଲି ମୁଁ ଆସୋସିଏଟ ମାନଙ୍କୁ ଯଦି ସିପିସ୍ ଟା ପଢିଦେବେ ଆରମ୍ଭରୁ ଶେଷ ଯାଏଁ ସବୁ କନସେପ୍ଟ କ୍ଲିୟର ହେଇଯିବ ସବୁ ମ୍ୟାଟର ଏଜୁକେସନ ମ୍ୟାଟର ଯୋଉଟା ମୁଁ ସବୁଠୁ ଡରେ ମୋ ଜୀବନରେ ସେଇଟା ବି କ୍ଲିୟର ହେଇଯିବ କାହିଁକିନା ତାର ଓଭର ନାଇଟ୍ ଆମେଣ୍ଡମେଣ୍ଟ ହେଇଯାଏ ମୁଁ ତାକୁ ପାରିଲିନି page your lordship will kindly see the impugned order page 45. Page 45.
Hmm.
May I place it, ma'am?
Yes.
Having heard both the parties to the dispute and going through the evidence on record, I am of the opinion that the respondent number 1 has been residing in ward number 7 of Noyagad NSE for more than 10 years, as it is evident from RI report by the Annexure 2 submitted by the appellant and inquiry report of CDPO Noyagad. There is no bar against a person belonging to village Aningi Sahi to reside in Noyagad town. Article 19 of the Constitution of guarantees liberty.
ये पे केवटो साई ना कौन लिखा है ना जो ये था
वार्ड नंबर 7 केवटो
हाँ वार्ड नंबर 7 केवटो साई मैं ऑफ नयागढ़
ନାଇଁ ସେଟା ତାପରେ ଦେଖନ୍ତୁ
ମୁଁ ସେ ଜିନିଷଟା ବୁଝିଲି ତ ଜାଣିବି ନା ଆଚ୍ଛା ହଉ ତାପରେ
ତାପରେ ଇଲେକ୍ସନ ସେ ଆର୍ଟିକଲ 19 ଟା କୋଟ କଲେ ଯେ ଯୋଉଠି
ଗଲା।
ରହିପାରିବେ ସେ
ଗଲା।
ଚାହିଁବେ କନଷ୍ଟିଟ୍ୟୁସନ ଫ୍ରିଡମ ଦଉଛି ଜାମ୍ମୁ କାଶ୍ମୀର ଛାଡିକି
ହୁଁ।
The voter list that is annexure 1 submitted by the appellant is not the conclusive evidence of residence. Moreover, residence certificate issued by the Tahsildar Noyagad still holds good, having not been asked.
so he accepts that the person is a resident of that area.
Area on the basis of a residence certificate produced later on.
All right for whatever not only on that he has also referred to the RI report.
Yes,
He has also referred to the RI report.
yes.
So
RI report is for grant of that certificate.
so unless you come up with a case
Madam.
definite or a positive case saying that she does not belong to this area but has obtained a certificate fraudulently,
Right.
I have myself delivered a judgment in that regard. I have negatived this contention. I think yes. Because simply by saying that she couldn't produce the residence certificate as provided in the advertisement, that may not hold good unless you say that she belongs to a different area.
Now, your lordship will decide whether even non-availability of, my lord, had it been a case,
This will prevail over the advertisement.
yes, my lord, that's what I am saying. I'll give one citation that which will show that an incomplete application, no time lag can be extended. I'll give that Supreme Court judgment to your
No,
lordship.
that I know. That
My lord, that's what I am saying. So if I fail, I fail. This I was trying to attack in aid of Order 41 Rule 22. But leaving aside that also, the certificate was born post facto the cut-off date of the application. So that your lordship will decide. And if your lordship votes yes, post facto the application, it can be done. But I lose. That's all, my lord.
No, it's not a question of winning, losing. Let me just find out.
I lose, my lord, the opposite party. I am losing, my lord. I am just assisting your lordship,
No, I'm also saying about the opposite party.
my lord.
Upon hearing respondent may object to decree as if he had preferred a separate. Okay.
No, ସେ decision ଟା କିନ୍ତୁ ଦେବି ସେ decision ଟା your lordship decide
That extension though.
extension ଆଉ ନ ଦେଇଥିଲେ ଆଉ ହବନି ସେଇ decision ମୁଁ ଦେବି ଆପଣ ତାପରେ decide କରିବେ କିଛି ଅସୁବିଧା ନାହିଁ ସେଟା ଖାଲି ଏତିକି ମୁଁ assist କରୁଛି ଆଉ ଏଇ ଯୋଉ order 41 rule 22 କହିଲି I may be having little so far as that residence certificate is concerned but that your lordship will decide. I'm just assisting that this is the document I produced whether that's plausible or not.
That will be acceptable. What you are saying, 4122 will be acceptable. Yes.
Right.
You can attack this finding,
Right.
provided it is your specific case that she doesn't belong to this area.
That's our case.
So to which area does she belong? That you must come up with a
Yes,
specific.
that we
You
have
will
stated.
file a counter in this
That-
case. Doesn't matter.
ଏଠି counter ମୁଁ ଏଇଥିପାଇଁ ଫାଇଲ କଲିନି ଯେ your lordship will decide on the basis of materials on record.
I will. But
Right.
this is a factual aspect which you are
But is
referring
it
to.
factual that we have said ସେ ଯୋଉ annexure 1 ରେ ଆମେ କହିଛୁ
Annexure 1.
ଭୋଟର ଲିଷ୍ଟ ରେ ତାଙ୍କ ନାଁ ଏବେ ବି ଅଛି ସେ ସେଠି ବାହା ହେଇଛନ୍ତି ସେ ଏରିଆରେ ଆମେ ଯୋଉ
Annexure 1 କୋଉଟା Annexure 1?
annexure 1 ମାନେ ସେ ଯୋଉ ଭୋଟର ଲିଷ୍ଟ ଟା annexure 1 to the appeal memo
That we don't have, but
ଅଛି ଯେଟା ଏଠି ଅଛି ଏଠି ବି ଅଛି ସେଟା ତଳକୋଟରେ ପ୍ରଡ୍ୟୁସ ହେଇଛି ତଳକୋଟରେ ରେକର୍ଡ ରେ ଅଛି and in fact in all these cases I think the state may produce both the original and the appellate records that will help your lordship to decide the matter better.
Yeah, let us
This
see.
document was produced. I'm just not for this case. I'm saying in all cases with a counter and all these things may not assist your lordship properly so far as the adjudication of these kind of matters are concerned. But this flows from a forums, one forum to the other. So it's not a direct read where a
so this
adjudication.
village, Angi Singhi,
Again,
under Saranakul PS.
again.
This is not the area of the Anganwadi center.
No, ଅଳିଚି ନୁହେଁ ତାଙ୍କର ଆମର ସେଇଟା ଗ୍ରିଭାନ୍ସ
May I just submit 2 lines?
Just
ସରି ଗଲେ କହିବେ ଆପଣ ରିଜାଇଣ୍ଡର ଦେବେ
inquiry report. The resident certificate shows you to be a resident of Noyagad.
Yes.
Simply Noyagad. Noyagad town मतलब
ଆଜ୍ଞା ଯୋଉଟା
What a
ଦରକାର
municipality.
କ୍ୱାଲିଫାଇଂ ଯୋଉଟା କ୍ୱାଲିଫାଇଂ ପାଇଁ ଦରକାର
କାଇଁ?
ଅଙ୍ଗନବାଡି ସେଣ୍ଟର ଏରିଆଟା
Anganwadi center area पर आगु तो कोडी Kyoto sai. Kyoto sai is within Anganwadi. Within that
Ward number
Anganwadi center
7.
is. Eh?
Ward number 7.
Number 7.
That is within Noyagad.
Yes.
That is
Yes, ma'am. Ward number 7 and Kyoto side. That is Kyoto side. In fact, the Balwadi worker was nobody disputed. I was not a Balwadi worker.
ସେତିକି ମୁଁ
Balwadi worker is a
ଛାଡ଼ିଦିଏ ଟିକେ ଆଜି ଇମୋସନାଲ ଅଛନ୍ତି ମୁଁ ଜାଣୁଛି this person is a Balwadi worker so therefore he is emotional.
No. So I want to understand that she is not
I am also emotional.
she is not a resident of Noyagad.
ସେ ତାଙ୍କର ଦେଲେ ଏଠି ଯୋଉ page
The
24
certificate says, Mr. Mishra, the certificate says that she is a resident of Noyagad.
ଆଜ୍ଞା
But your claim is that she is a resident of village Angisingi,
ଆଜ୍ଞା
not Noyagad.
ନା
This Angisingi comes under Saranpur police station.
ନାଇଁ
So that is your case.
ଆଜ୍ଞା
All right.
ତାପରେ ଆଉ ଗୋଟେ କଥା ସେ ଯୋଉ ତାଙ୍କ ସାର୍ଟିଫିକେଟ ଟା ଟିକେ ଦେଖିବେ ଖାଲି ଆମ ସାର୍ଟିଫିକେଟ ଟା କାଇଁ
I am of the opinion that
where is that residence certificate of ours কোথায় আছে
this finding is what Mr. Mishra is saying. There is no bar against a person belonging to the village Angisingi to reside in Noyagad town.
ଆଜ୍ଞା ସେ ଅଛି କହିଛି ସେ ଆର୍ଟିକଲ 19 ଅନୁସାରେ ଟିକେ କନଷ୍ଟିଟ୍ୟୁସନାଲ ଆସ୍ପେକ୍ଟରେ ପଳେଇଲେ
All right. So that's all.
ଏଇ ଦିଟା ଉପରେ ସାଇଟେସନ ଦିଟା
Yes, anything finally 1 minute.
Just to add 1 minute.
1 minute तो मैं देखली घंटा कौन.
Still, my names also continues in Noyagad constituency voter list. If my learned friend doesn't consider me as a resident of Patak after staying 25 years, so in a lighter vein, still my name continues.
Quick. But no time for lighter vein now.
So Angi Singh village, admittedly, she was a resident of when she was at school. She is staying at Noyagad, ward number 7. Therefore, she was engaged as a Balwadi worker. That was the document I am citing. That was taken.
Where is that document? Where is that document?
Yes, madam. Page number 22, my lord. She is 2004, my lord. Page 22 of the writ petition.
Yes.
Unless I am a resident, I cannot be engaged as Balwadi early child care education, madam. And that was also accepted in the counter also. In the appellate authority also accepted that it is undisputed. So residence part, Lord, as my learned senior indicates, since my voter list is, my name is indicated in the voter list of Angi.
All right. I got it. Hearing concluded, judgment.
And I will also just ask you, note whether a Balwadi worker, that resident is a criteria.
That is my file, their note of submissions and memo of citations, if any, within a week. Not within a week, within 3 days.
I have already.
ଟିକେ
Clause 8 no time ହବନି vacation ଆସିଯିବ so within
ସୁମାନ ଦଉତ ନା ତା ପୂର୍ବରୁ ତ
ଆଜ୍ଞା
ସୁମାନ କାଲି ପରଦିନ ଆଉ ଆଜି ତ ମଙ୍ଗଳବାର ହେଇଗଲା
ଦେବେ 3 days ଦେଲେ ଆପଣ ଦିଅନ୍ତୁ.
That clause 8 ଟା ଖାଲି ଭୁଲିଗଲି କହିବାକୁ. Undertakings are acceptable from the Balwadi workers with regard to HSC certificate. Once the HSC certificate is acceptable, which is minimum criteria, that undertaking can be also that
মানে
Mr. Das enough.
In fact, on a here for 25 years. On a serious note, I am here in Cuttack for last 40 years, my lord.
Yes. Item 10.
The clause 5A B dita ka achi sei notification re. Tikke set. I will cite.
Yes, Mr. Das.
My lord, on behalf of Mr. Bimbisar Das, kindly pass over the.
Pass over. Item 11.
My lordship. Last occasion,
I am at the open number 5. As per order of this honorable court on 27th June 2016, only one certificate is. I am filing only one certificate, the TC of open number 5.
Yeah.
the birth certificate and your lordship see the last order. Birth certificate as well as 8 pass certificate
Is a transfer certificate.
is to be produced.
Then counsel for the opposite party number 5 files a copy of the transfer certificate issued by the headmaster. Nigamananda Vidyaniketan. Same be kept on record. Yes.
My lord.
What is the matter? Yes, what is the
appearing
matter?
for the opposite party number 5. Opposite party number 5 selected and appointed as ASA. I am the petitioner. I am challenging her selection and appointment on the grounds that the Lordship kindly see the guideline filed by the opposite party number 3 CDMO at page 6 of the counter filed by the opposite party number 3.
Yes.
That is at page 6.
Yes, I've got it.
My lord. Page 6 is relevant. That is the criteria for selection of ASA.
Please place it, sir.
Your Lordship kindly see the clause 1. ASA must be primarily a woman and resident of the village. Second is she should be preferably in the age of 25 and 45 years. Third, she proposed in the meeting. Next line. Then there would be a discussion on the most eligible candidate for appointment as ASA. If there is unanimity on one person, then same person would be selected. Your Lordship kindly see thereafter. If there is no unanimity, then selection of ASA would be done through a procedure drawn a lot from among the names of presence of the ward members. Your Lordship kindly see. Selection was over. Opposite party number was selected and appointed. Irregular and illegal selection was challenged by, I make representation to the higher authorities. And thereafter filed with a writ petition before this Hon'Ble Court that was disposed of, directing the collector to cause an inquiry. But that was not done. Opposite party number 3 and 4 disposed of the representation confirming the selection and appointment of the opposite party number 4. Your Lordship kindly see, I got some document under RTI. Lordship kindly see clause annexure 11 at page 5 filed by the petitioner.
Annexure 11.
Additional affidavit. Annexure 11.
Yes. Yes.
Annexure 11. I am giving they check this. It says that I have not supplied these things.
I have not received the copy.
Have you received the rejoinder? Have you received the rejoinder? Sir, have you received the rejoinder?
No.
Let copy of the rejoinder and additional affidavit filed by the petitioner be served upon learned counsel for the opposite party number 5 in course of the day. Is this matter next week?
Item number 12.
Lordship, I prepare and pass over on behalf of Senior Advocate Mr. J.K. Rath.
Your password lagu nahi dekhiya. All right.
Grateful, Lordship.
Item 13.
That's a matter relating to approval of additional section teacher. We need 1 week time to file rejoinder, my lords.
Approval of additional trained graduate post.
My lords. And the counter has been filed by the state. 1 week time to file rejoinder.
Counter was filed when?
There's a
Counter was filed?
Sorry, my lord, so that is
26/6/2020, 4 ବର୍ଷ ତଳେ.
2 years. So there.
4 years.
There's a they served the copy on 31.
Learned counsel for the petitioner seeks time to file a rejoinder to the counter filed by the state. Place this matter vacation for
25th June.
25th June. Rejoinder if any be filed in the meantime.
Also another one, earlier also headmaster was appearing through an advocate. The advocate is no more. The press notice, my lord. To OP number headmaster, OP number 4.
OP number 4, who was appearing?
So he is no more, my lords.
Who is appearing? No, he is no more.
PK Mohanty.
Okay.
Remember,
Ki again?
Prashant Kumar Mohanty.
We'll see on that day.
my lords.
Item number 14.
ଏ ପାଠଟା କେମିତି ତଳକୁ ଆସିଲା? ପାଠଟା କାହିଁ ତଳକୁ ଆସିଲା? ପାଠଟା ତ ପାଠ ଲିଷ୍ଟ ଗୋଟେ କରିକି ତା ଦେହରେ ଗୋଟେ ତଳେ ଗୋଟେ ଉପରେ ଇଏ କଣ? Yes.
My lord should see, kindly see order dated 15th of February 2023, order number 10, passed by my lords. Lordship got that order, ma'am?
Yes, yes.
My lordship wanted specific instruction as from the merit list whether those 5 persons verified that document or not. We say that para 10 and 11 that they have never come and appeared for the purpose of verification, but they have been engaged.
Yes, sir. State. This order requires to be complied with. Paragraph 10 and 11 of the writ petition were not answered. That is why this court directed you to obtain instruction, specifically on those aspects.
Nothing has come thereafter.
All right, we'll take it up after vacation. You obtain instruction in this regard.
Matter of 2017, my lord.
I know, we'll finish it. Don't worry, once the pleadings are complete, it will.
Right.
This court observes that the order dated 15/2/2023 has not been complied with as yet. Release this matter. On 25th June, the previous order be complied with positively. Failing which the matter shall be disposed of on the available pleadings.
Correct.
Item 15.
Item 15.
May I please, your lordship? Lordship have a glance order dated 23/11/2023. Lordship already observed that the order of the tribunal has not been challenged before any court of law, so it should be implemented as early possible manner. But till date, they have not implemented. Your lordship granted several times and also granted time to, if they wanted to file any show cause, they can file, but they have not.
Yes, the order has attained finality.
The result in WPC 18245 is determinative of 2018.
Yes.
Because the order which is complained of having not been complied with, that was impugned in 18245 of 2018.
Yes.
So unfortunately, I don't have the result of that.
No, I'll tell you. Said order of the tribunal was challenged by the state before this court in WPC number 18245 of 2018.
Yes,
which has since been dismissed as per order passed on 12/3/2020 by a division bench of this court.
Thereafter, what they have done, I will have to ask.
No, this order was passed in November 2023 on a contempt application. I'll grant you 7 days time. Comply it. Who's to comply?
It is the state.
Statement of which department?
Health and Family Welfare.
Health and Family.
Yes. 7 days time. Maximum.
No, the government.
Thereafter, there will be a show cause.
Government has already
15 days, 15 days may be granted.
This court, by order dated 23/11/2023, observed that the orders of the tribunal as well as of this court passed in the writ petition have become final, and therefore there is no other alternative for the state but to comply with the orders. Last chance was granted to the state to file compliance affidavit within 3 weeks. Stop. It is unfortunate that said order has not been complied with even till date, though several opportunities have been granted. The matter is adjourned to 25th June as last chance. On which date the state shall file compliance affidavit, failing which appropriate adverse orders shall be passed.
Hon'Ble.
Item number 16.
Sir, item number 16, when a cinema star, 75% visually handicapped, petitioner in person. Sir, tomorrow, Chari,
Ticket.
Sir.
Opinion of the law department.
Sir.
Last time mothe kuha hitla. Order hitla se. Mothe last time kuha hitla. What it can be done.
Yes.
First week of reopening re roho. Mu koi deis ta.
Corridor.
Jane.
Corridor comply kar diyo to dekho.
Jane deis.
He is
Sir,
knocking the doors of this court time and again.
Upon quietly sab.
Korte debe sarla kar. Korte. Why will a citizen knock the doors of the court time and again? देखो कौन ही पे Learned State Council requests for time to comply with the previous order on the ground that the relevant file of the law department could not be instantly traced. Place this matter on 25th June. Stop the previous order be complied with positively. Best of one.
Sir, मुझे कोई ध्यान से
किसी को नहीं
अब लाइन को
किसी को नहीं व्यस्त आपन भाई जा कहया कथा कुआ होछ
सर
से चेष्टा करछथि
Item 17.
Transfer of matrimonial suit from Badampur district Bargad to Patnagarh district Balangir.
notice जाइतला
Notice दी थरा गलानी she is avoiding to receive. Again, the 8 बार order जाइतला
notice on opposite party has again returned undelivered with postal endorsement absent since last 7 days. Let a copy of the transfer application be served upon Learned State Council, who shall ensure service of the same on the opposite party through the IIC of the jurisdictional police station, indicating that the matter shall be taken up for hearing on 25th June. List this matter on 25th June. Interim order to continue. Yes. Item 18. Free copy of this order be handed over to the State Council for compliance. Yes, what is this matter?
My lord, this is transfer application filed on behalf of the wife, my lord.
Yes.
Praying for my lord.
Any chance of settlement?
My lord.
Yes.
Petition is ready, my lord.
Sir, any chance of settlement?
No.
No settlement. All right. We'll consider. All right. We'll take up the transfer application. You want it to be transferred from which place to which place?
My lord, from Jajpur to Khordha, my lord.
Jajpur to Khordha. On what ground?
The petitioner is the wife, my lord. He is living in the remote area of the Khordha, my lord, Begunia. And they after she filed a maintenance case before the Learned Family Judge Khordha, my lord. After getting notice, the husband had filed this present civil proceeding before the Learned Family Judge Jajpur, my lord.
Yes.
Is a lady, my lord. No.
Yes, what do you say?
On last occasion, my lord has suggested for hearing on virtual mode or for hearing of the court by the OP. And the Lord Council had taken time to get instruction from the party. But today he is submitting for the transfer. Rather, I have submitted some documents, that is Panchayat Faisala, wherein she has admitted that she is involved with some adultery ground. And that's why she has opted for divorce on mutual consent. Instead of opting for that.
So that is what I'm asking you for mediation and you are not agreeing.
No, she is not agreeing now. Rather, I'm filing the CIP case.
So you don't agree for mediation?
Yes, from 2017, she has gone out. From 2017.
No, that's all right. That's all right. But he is now agreeing for mediation. If you decide to separate by filing a 13B application.
On that score, we are ready.
Marriage was solemnized on the special.
They decided in the mediation.
That is only for harassment is filing.
No, that is a different matter. This court will not consider whether she is harassing you or not. This court will consider whether you have a case for transfer or not. Now,
yes,
since earlier there was a Panchayat Faisala Nama, why don't you, and there is a possibility that the matter can be also settled. So why not try for mediation? In course of hearing, it is stated at the bar that, yes,
Notice has also gone, but thereafter she has not.
yes, state.
It can be settled because both are.
No, state. What happened? Notice has been served.
But the 19th is a place matter.
No, not a fresh matter. Order is it. I said on 2/4/2024, I had directed.
9/4, I have served a copy on that.
Yes.
Notice has not because I think it is the first time it has.
No. 2/4 ରେ ଆସିଛି ତାପରେ 2/4 ରେ ସେ order ଟା ହେଇଛି.
ଆଜ୍ଞା ତା ଆଗଥର notice ଯାଇଥିଲା ସେ receive କରିକି ଆସି ନଥିଲେ. And she has appeared on 29/4 before the court below also.
Yes.
I have also intimated in the court below by filing a memo.
As requested by State Council. The matter is adjourned to kebe? Vacation for
2nd July.
2nd July. The previous order be complied with positively.
May I pray, man? I will file a time petition that may be allowed there.
In the meantime, if any application for adjournment is moved on behalf of the petitioner in the court below, the same shall be considered, having regard to the date fixed for hearing of this case.
Oblige. Urgent copy.
Urgent copy be granted.
May I please, Your Lordship? Transfer of the GR case from Rumor Court to Nabarangpur. Last 2-3 occasions, Lordship directed to government to take instruction regarding the registration of FIR.
FIR has been registered.
And subsequently,
Item kete eta?
Item 20, my lord.
Item 20, yes, just one.
Item 20, my FIR has been registered as per the instruction, oral telephonical instruction I have taken, that investigation is going on.
No, Rumor Court case number 54 of 2024 has been registered.
Yes, ma'am.
Subsequently directed.
And the matter is under investigation, that also you had stated.
But on that occasion, I have received instruction that PS case number also and such and such offences were registered. And your lordship directed for
regarding the further progress of the investigation in the matter.
Yes, telephonic instruction that the investigation charge sheet has not yet been submitted.
Charge sheet has not been submitted, so we'll wait till submission of charge sheet, then we'll transfer it.
Your Lordship. Your Lordship.
Learned State Council submits that investigation into the matter is still in progress, and that the charge sheet is still in progress. In such view of the matter, list this case on 2nd July.
Lordship.
Is there an interim order?
No, madam.
No interim order.
No, madam.
How good interim order ଅଛି ନା ନାଇଁ?
Lordship, then we continue.
Yes.
If any interim order, then that may be continued.
No, there is no interim order.
Your Lordship.
Item 21.
Oblige.
This case, so notice has been issued to the.
Notice has been served also. From the office note, office note indicates that notice on the office note as well as the postal consignment report shows that notice on the opposite party has been duly served. There is, however, no appearance. Kepe service is 25/4. Since notice appears to have been served only recently, that is on 25/4/2024, in order to grant an opportunity of hearing. In order to grant one more opportunity to the opposite party to appear, list this case on 25th June. Interim order to continue.
Okay. Item 22. Next.
Transfer has been filed in this case, my lord. Also, copy has been served.
What is this matter?
Here, my lord, I have challenged the order passed by the opposite party.
Counter has been filed. There is no counter on record. File a hard copy.
Hard copy was on the last occasion, perhaps hard copy was filed.
By hard copy file is it is not there.
It was filed on 16/4.
Yeah, it has been filed. Probably it is reflected in the order, but it is not in the record. Anyway,
sir,
what is this matter? Can we take it up for final disposal?
Yes, my lord.
Take it up after vacation. 2024 matter. Thank you.
Yes, my lord. Interim is there that may.
Interim order will continue. As requested by the counsel for the parties, list this matter. Vacation for a date for us. 2nd July. Interim order to continue.
Obliged.
Item 23.
23. Nobody is appearing.
Yesterday, that matter was before my lordship. My lordship directed government advocate to take instruction whether the matter will file second appeal or issue notice will be issued.
Office to indicate whether notice on the opposite party was office note कीजिए देना था. Second. Is this matter tomorrow? Office to comply with order dated 1/5/2024. I had passed an order directing the office to say whether notice has been served or not. Sikisi korna.
Already I have entered appearance yesterday.
Kali apna फिर?
Yes, yes. Already entered appearance file भोकलाद ना.
It is not there. Kali रो ये बिल्कुल order कौन है दिखे? Kali order? सेटा कोहु ना दे कोही ना. Entered appearance. Yes. So you have appeared.
Already entered appearance. Your lordship was asking Mr. Government Counsel whether a second appeal or a notice will be issued in this case.
But in this case, this order is of the year 2015.
15.
ताले तो notice jibo. Mr. Das?
No, here what has happened, the collector has passed the order after the new rule has come into force.
No, maybe, but on being remanded by this court.
This was from earlier.
That is what I wanted you to examine.
Notice to
The original matter relates to 2015. It was brought to this court. The ADM, Mr. Das,
sir,
2015, the ADM passed an order.
Yes.
It was challenged before this court. This court remanded the matter to the collector. So how it will relate to that case, obviously.
No, of course, it has originated from much earlier.
No, issue notice. Issue notice. I am not passing any order. We'll see that point can also be raised later.
Yes.
Issue learned State Council accepts notice on behalf of opposite party numbers 1, 2, 3, 4, and 6. 5 extra copies of the writ application be served upon him within 3 days. Issue notice to opposite party number 5 by registered post with AD. Returnable within 4 weeks. Requisites be filed within 3 working days. Place this matter July record. 9 July. To re-engage the petitioner. I hear a notice as above. Yes.
Item 24.
Please. Lordship, kindly see the previous order.
Previous order.
Okay. And then the Lordship are directed to get instruction on Rule 10(5)(b) of the Orissa accounts from data entry operator, whether pendency of the case they are going to consider negatively or positive.
I've said any promotion granted to the post of data entry operator shall avoid order.
But also your Lordship directed in 5838, your Lordship kindly see. In this case, the order number 4.
By the next week, my lord, we are going to file the counter.
Next week, no authority.
2024 matter asu. Apar to interim order achi. Vacation पर asu. We'll hear. Counter दियो तो 2024. I am overburdened with 2016 matters also.
That is what I am observing. I made a mention 2 weeks before to list the matter, but I find that my matters above are not over. So how can my matter? That is why it is pending.
You have to treat it as a.
But anyway, the
incompetence of the judge.
No.
Because so many matters, I have to give justice to everything. No. Okay. Next week. Place this matter in the week commencing 13th May. Yes.
Item 27.
Item 27.
I filed 2 miss cases for petitioner number 2, my lord.
Yes.
While releasing all the 4 accused persons, my lord has directed they shall deposit 50% of 31,99,000. So almost 16 lakhs, 4 persons. Per head, my lord, 4 lakhs it comes. He's because he's since long he and his wife was in jail. He is unable to, my lord, deposit those money.
This is an economic offense, Mr. Rai.
I'll deposit some cash. Your lordship say have 50% cash, 50% copper.
No. 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 I have consciously passed this order. I will not modify.
Because since long, my lord.
No. 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 You want, I can convert it to, I mean, you deposit 50% of that amount upfront, the remaining amount through, I'll grant you time to deposit.
My lord.
All right.
That my lord.
The prayer for modification has been made on behalf of petitioner number 2.
Yes.
On the ground that others have complied. Others have complied. On the ground that he is unable to comply with the condition to deposit 50% of rupees 3199,000 because of financial stringency. It is submitted that in view of his long incarceration, he is unable to arrange the required money stuff. This court observes that the order granting him bail was passed on 7/3/2024. The petitioner has not been released as yet, evidently for his inability to comply with the condition of making the required deposit. So, since this amounts almost to refusal of bail, I am inclined to take a lenient view. The order dated 7/3/2024 is modified only to the extent that the petitioner shall deposit.
Petitioner number 2.
Petitioner number 2 shall deposit. Kete hua?
4 lakh hoji jane.
Jana ka 4 lakh ho.
16 lakh till 4
2 lakhs upfront at the time of his release, and the remaining 2 lakhs in equal monthly installments, with the amount of each installment being decided by the court. Yes. All other conditions shall remain intact.
Within such and such month.
The remaining amount shall be deposited in 6 installments.
6
within a period of 8 months.
Both the cases. There are 2 cases.
Same order?
Same order.
All right.
Petitioner number 2.
Item 28.
Extension of time.
First time it has come.
Yes.
That's it. Correction be made accordingly. Then 2 weeks for the time. Yes.
Item 29.
All right. On behalf of the Mr. Pramod Mishra, Madaraj expert, extension of time, second time.
All right. Same order. 2 weeks time for the correction to be done.
Item 30. May I present?
Also, we have glanced the previous order, Your Lordship.
Previous order, yes.
Juvenile, Your Lordship.
Out of Sarojini Sita is said to have been examined. Deposition of Sarojini Sita.
Sarojini Sita statement, Your Lordship, call for.
Yes. It has come. No, it has not come. Aukarashi, Sarat Chandra Panda. Email aschi, isn't it? Email aschi kahin nahi. Office note. Flag L. Vachinta Rao. Diyon ko raschi. Same ଜିନିଷ repeat ହେଇଯାଇଛି ଦେଖିଲ ଆସିଛି କି
Para 16, madam.
It has not come. It is not there.
That the Sarmishta said.
No, Sarojini Settha.
Sarojini.
Sarojini Settha is the prime accused of the case.
It has not come. Sarojini Sittha. The court below is directed to transmit copy of the deposition of said Sarojini Sittha by email to this court. ये देख लो कौन है हाँ पास ओवर कर दें पास ओवर कर देखो कौन है पास ओवर if necessary we'll take it up after recess.
After launch alerts.
Yes देखो
Pass over item number 4.
pass over item 4.
My lord, in fact, my lord, in this case,
Yes.
my lord, there was a direction to me to collect that particular order of 1976 as well as
Order
the
dated author of Shastri as also the relief order be obtained in the meantime for perusal of the court. Yes.
I request some time my lord, to collect that year-old record.
Then
because
State
it is-
Council requests for some time to comply with the previous order. Let's this matter. 25th June.
Yes.
Pass over item number 5.
May I please?
Yes.
The last occasion, your lordships had called for the records.
He wanted some time to go through those records.
I am standing here with
The
records.
intimacy, that in lighter vein, my learned friend appears for the management. My learned friend appears also for my adversary.
Obviously.
So the intimacy of the management along with the person who's competing with the petitioner and will be gauged. So my learned friend can have his time, but this matter has been pending since 2009.
I'll take it up next week. I'll complete it.
May I just humbly pray that records be kept in the court and
yes.
Yes, I'm giving.
No. The Mr. Patnaik has produced the records. But the registers actually, not the records. The resolution book.
Resolution book and acquittances.
Acquittances. All right. Sri B.K. Patnaik Learned Counsel appearing for the management produces the original resolution book and acquittance register, acquittance roll register.
Yes.
They will not be kept in the court. Why will they be kept in the court?
I shall go through it. I have not registered. I have got it.
Let the records be kept with him. List this matter next week for final disposal.
Yes, yes.
Subject to your lordship's kind consideration, can it be taken up after lunch, any date after? 14th,
It's not possible. After lunch, I'm taking up another list, the weekly list. Only under exceptional circumstances, I'm taking. If it so requires, then we can take it up.
Obligation. So 14th, your lordship.
14th.
Obligation.
Pass over item number 10.
My lords, in this case, your lordship may kindly remember, your lordship advised me to consult Mr. Senior Advocate Mr. Buddhadev Rautrai about that amendment, Education Act amendment, whether it has been challenged or not.
Similar matter, the senior counsel argued already the matter. I've already kept reserved for judgment.
That I didn't know, but Mr. Rautrai told me that some orders, 2 judgments have been rendered by coordinate benches. He has assured me to give the copy of the judgments.
Judgment had given to my.
It has already been handed over.
That judgment.
I did
Which
know
judgment?
that.
Satpath is.
Vaijayanta Das.
Yes, that had given.
This has been reported also in the.
Recently, it is.
Recently.
That will be helping me. That's what I.
Sri Das submits that a request for some time to cite certain decisions passed by coordinated benches of this court in support of his contentions raised in the present application. Vacation per year. Vacation per year. Since 2003, I will.
As your lordship pleases.
Second July.
Call it 2nd July. Let's this matter on 2nd July.
Pass over item number 12.
Your lordship can have a look to your order passed on 16th of April 2024.
Yes.
London Council for the opposite party number 3 seeks some time to obtain necessary instruction to file a counter affidavit.
You are private of this party?
Yes, ma'am. Private, lordship.
Management.
Management. You filed a counter?
No instruction, lordship. May kindly send the director send a press notice, lordship.
Why?
Not
Notice
able to.
and you have no instruction, so I will.
Not able to contact with him, lordship.
So you file your memo of no instruction, then only I will issue notice. File a memo of no instruction.
I will.
What, why you will, I don't understand, sir. This is a 2013 matter. Why are you not ready? And this has been passed over also once. You should be ready. You are here to assist the court, sir.
Sorry.
You cannot thwart the process of justice. Sir, what is your instruction? If you have no instruction, file a memo of no instruction. I can issue notice again.
Okay, let's try.
You should have done that.
Sorry.
So,
I will file it.
what, when will you file?
No instruction.
Place this matter tomorrow.
So I don't know, 25.
Yes. What is this matter?
Before Lord's board yesterday, my lord, friend was saying that there is a provision for second appeal before the.
There is a provision for second. Have you gone through?
Yeah.
Have you gone through? ମୁଁ ଆପଣଙ୍କୁ ଦେଲି ଟାଇମ ଦେଲି ଆପଣ ଦେଖିବେ ବୋଲି we have that ଆମ ପାଖରେ ଅଛି ସେ ଇଏଟା ଅଙ୍ଗନବାଡି worker ହଁ that instruction is there. Is that instruction? I'll dispose of. The petitioner has challenged the order passed by the ADM Balangir in Anganwadi Appeal number 5 of 2022. This court finds that as per the revised guidelines for selection of Anganwadi workers issued by the government on 15/3/2023, the second appeal lies against the order of the ADM to the RDC of the concerned division as per paragraph 8, paragraph 8 bracketed G
8G.
of the said guidelines. When was this order passed?
It was passed on 13/12/2023 by the ADM.
And when did you file this writ application?
It was passed on the 18/3/2024.
The writ application is therefore disposed of, granting liberty to the petitioner.
So far, this I think new guideline was come in force on 15/2/2023.
15/3/2023.
Yes, 15/3/2023. There is an instant case that advertisement of the year 2000. I don't think it will stand on the way that annexed.
No, he's right. Advertisement is of the year 2021.
Yes, sir. It will not.
Advertisement is of the year 2021. But the cause of action for filing of the challenging the trade appellate order, that only came on 13/12/2023.
It will not retrospectively.
You
examine it. Examine it, we'll take it up.
My submission, only one submission. Here in this case, the scope of giving an appeal, another chance of appeal, so that both factual as well as the legal asset both can be taken into consideration.
If it is because you see, it is not the question of the impugned order alone. The impugned order flows from the selection which is pursuant to an advertisement.
Yes, ma'am.
So that advertisement is the basic cause of action.
Yes.
Yes, madam.
And that advertisement was issued under a different set of guidelines, which is 2/5/2007.
Yes.
This, when admittedly these guidelines had not come to light.
Yes, sir.
Isn't it?
Yes.
So I don't think
here, my lord, only one forum has been introduced in the meantime.
No.
As your lordship pleases, I don't, because my lord, then in that case, my lord,
I'll have to issue notice.
My lord, no.
Notice is there. Other side already clear.
Counter. In our counter, my lord, I have taken this also and as on the ground.
Then you examine it, will dispose of the matter. You examine it in this light.
Yes.
And I prima facie am of the view that the advertisement being of the year 2021.
More on merit also, my lord, it can be decided. I
will decide it.
Because, my lord, I have already filed.
Vacation for us. Intimate ଅଛି.
No intimate there.
Intimate ତ ନାହିଁ, ସେ ଥାଉ vacation ପରେ ଆସିବ 2024 matter କଣ ଅଛି?
Sir, rejoinder file କରନା.
ଦେଖିଦିଅ. As requested by learned counsel for the petitioner, is this matter?
2nd July.
2nd July.
As it was.
Yes. How? Item 30 ଟା କଣ ପାଇଁ ସେଟା ଦେଖିବେ ସେଟା କଣ ଆସିଛି ନା ନାହିଁ ସେ Sir, your time starts now.
I have the time. I will abide by the time.
No, I just said it starts now.
No, because I've been continuing. I'll finish, then let him say what.
You will give a reply, sir? Later. Yesterday we decided for 10 minutes and 5 minutes.
Yes, exactly. My lord,
And it starts now.
now my lordship says he has given a judgment of the Supreme Court relating to Sanjay Kumar, Justice Sanjay Kumar. Has my lordship got it, my lord?
Pankaj Bansal.
Bansal. My lordship says page 12, running page 12, paragraph 13.
Paragraph 13. Yes.
Fourth line.
Yes.
The only issue for consideration presently is whether the arrest of the applicant under section 19 of the Act of 2002 was valid and lawful. That is the limited question. Now, my lords, if I have not arrested him under 19, where is the question of this judgment?
No, but you have taken him on remand.
Taking him on remand, it was summoned, it was a custodial remand. He was in custody.
For a person who is in custody, he cannot be rearrested. He has to be only taken on remand. That is why, please read the next line. Next, continue with the sentence.
No, the fact remains, I'm not arrested him under 19. This is a factual aspect. If I have not arrested him under 19, if I have not arrested him under 19, how will this judgment be applicable? He says, while the accused, I've got the paragraphs, I'll show it only one line. While the accused was summoned, he was arrested at the time of summons. He was not an accused. As I told my lordship, he becomes an accused only when the special judge takes cognizance.
No, but what happens is, what you have read it, is that there's another word and whether the impugned orders of remand passed by the learned vacation judgment.
Yes, I'll come to it. Now, I took him on custodial because I cannot issue someone who is already in custody in a police case. So I bring him under custody and I examine him, find that he is guilty of an offence under section 3 and 4. If he is guilty and I file the 52(3) documents on the oath and give it to the district judge, special judge. What does the district judge takes cognizance? Once he takes cognizance, I let him go. I send him back to jail. My lordship would, send him back to jail. If I had the option to take him to my custody, I have not taken. What does the court write? What does the court write? That a case under section 3 has been made out from the order sheet and it is punishable under section 4. Where is the question of section 19? I have not arrested him under section 19. Is the first crux of the matter. Therefore, this judgment is of no consequence. Because the question for determination was, if I have taken him on remand under section 19, there must be grounds to believe that he has perpetrated an offence. And in absence of the ground, he could not have been arrested. The whole judgment within the four corners of all these pages says that. I admit to it. This is a case where the ED has faulted. Times without number. You call him up for summons. He comes there and then you arrest him. He is not an accused. How can you arrest him? I'm with the judgment. Two cases, two faces are never similar. These facts are different. My fact is different. He was involved in Narcotics Act. Proceeds of the crime is what I have taken cognizance of and hawala. Under 3 and 4. Scheduled offence, I have not taken any offence. And that is specifically stated. If I have not arrested him, I reiterate, under 19, where is the question of this judgment? My first crux of the matter. Over. Then 44(2), I come down to the next question is bail. If I have not arrested him, Where is the question of bail? I must arrest him. I must put him into custody. He is gone, he was already in custody. Now my lordship sees, the book is there, my lords, of Madan Lal's judgment, that is with my lordships. 169, page 169. The thick green book. 169.
169 where it starts with paragraph 17 is there.
Paragraph, it is submitted that the argument of the private parties, which is based on section 44.2.
Yes.
I will read 44.2. Based on 44.2 of the PML Act, that the twin conditions of section 45 are applicable only to the special court and not to the High Court is totally erroneous. Clarification under 44 was required as similar provisions of the special enactment has been interpreted to oust the maintainability of bail application directly to the High Court. When I read 44, his twin conditions have to be satisfied both ways. The court where he has to approach for bail is the court below, is the jurisdictional court, my lordship says. Is totally erroneous. The clarification under 44 was required. A similar provision of the special enactment has been interpreted to oust the maintainability of bail application directly to the High Court. Thus, 44 mainly deals with the issue of jurisdiction. Further, it is submitted that if the twin conditions of bail are held to be applicable only when the application is filed in the special court and not when the application is filed before the High Court, then such an interpretation would completely render the provision arbitrary. Now, let us read 44.2. 44.2. Notwithstanding, has my lordship got it? Notwithstanding, in this section shall be deemed to affect the special powers of the High Court regarding bail. He says High Court has the power regarding bail under 439 of the Code of Criminal Procedure, and the High Court may exercise such power, including the power under clause B of subsection 1 of that section, as if the reference to a magistrate in this section includes also a reference to the special court designated under section 43. So therefore, the jurisdiction is you have to move it in the special court, and if it is rejected, then you come to the High Court. And the anticipatory bail has not been stated. Under 439, they're saying, so High Court is passing orders time and again on anticipatory bail. He says anticipatory bail is not there. And in that judgment it is there, I'll show it to my lordship. Anticipatory bail is misconceived because he uses the word 439 and not 438. Have I made myself clear?
Yes.
Therefore, now if the jurisdictional court, if I have not arrested him on the 19th, number one, he has to move for bail because what I have made out of cognizance has been taken under 3, punishable under section 4. That is under PML Act for proceeds of the crime and hawala. My lordship would visualize. I have taken cognizance, the special court has taken cognizance for proceeds of the crime under 2 LV of the definition proceeds of the crime and hawala, which is there under 50 in his oath. It is vividly there. So therefore, I have taken him into custody. I have not arrested him on the 19th. I don't know why has he come here and filed it here. My answer is so simple, my lords. My lordship would visualize this. And that is the judgment of Madan Lal's case. It is so simple. But I made notes to show that the judgment which Pankaj's judgment is justified. Why? What I was saying to my lordships earlier, that he is not an accused, still complaint is filed. Even if the complaint filed is still not an accused. Only when cognizance is taken under section 3, he becomes an accused. Otherwise, I am asking you to come for giving evidence, for collection of records.
All right. So that's all.
That's all. Obliged. Have I taken the last 10 minutes?
Exactly within 10 minutes.
Exactly within 10.
And I've given my written note of argument, which I did not show the others, where the Madanlal says anticipatory bail is totally misconceived before the High Court.
This is not anticipatory.
This is regular.
No, I'm just saying, and bail also. He says you have to go down to the court below. Then come to the High Court on the 4th and 10th with all its limitations.
All right.
That is all.
A brief reply, sir.
Madam, here is a case, my lord. If I have understood my lord, properly, the submission is that the order of cognizance and the filing of the complaint. So he says, I cannot be termed to be an accused before the cognizance is taken. My lord, may see the order sheet is there with my lord.
Yes.
When the cognizance was taken and when the complaint petition was filed. Perhaps my learned senior has not seen that.
No, 27(4).
Let me see. No, my lord. The cognizance has been taken on 7/8.
Yes.
But
7/8.
But complaint petition under Annexure 3 has been filed on 4/8.
Complaint petition on 4/8.
4/8. So if the submission of my learned senior is, complaint petition cannot be filed or charge sheet cannot be filed before the cognizance is taken. Cognizance is, again, my lord, I am saying
7/8.
7/8. But let me see the complaint petition. That is
second petition or the first?
Second.
Yes.
4/8.
Annexure 2.
My lord.
Yes.
4/8. At page 13.
Yes, yes.
That is the answer to his query. That too, even the first complaint which has been filed by the authorities, Directorate of Enforcement Government of India, my lord will see that is at page 8, cause title. Sorry, my lord, page 6. How the present petitioners,
yes,
how they have been designated.
Obviously accused.
Accused. So we were accused on 27 when the first petition was filed with a prayer to take the accused persons, the present petitioners, on remand. Basing upon that application, the order was passed by the learned session judge cum special judge designated court. And the order which has been passed by the special court is a cryptic one, shows non-application of bind, and as required in Pankaj Bansal's case. Second thing, on facts, what is their case? The predicated offense or the scheduled offense is 21C and 29 of the NDPS Act. What is that allegation? That a case was registered under Sahib Khunta police station by PS case number 352 of 2022, wherein petitioners, 2 petitioners and 5 others, they were arrested while they were in possession of 10.39 kgs of brown sugar, which worth around 10 crores 39 lakhs 40,000. They were arrested. Articles have been seized. If my lord will see the chart given by them, after being due interrogation under section 52, and even beforehand to take them on remand, what is their allegation? What is their statement? That we
this illegal proceeds of the crime is 10 crores 39 lakhs. If the articles have been seized and we have been mentioned in the seizure list, for that reason, I prepare a short note. I have given the seizure list and forwarding report where they have been mentioned as peddlers. They were peddling, they are working for that main accused Raja or Ayub, whatever, whoever it may be.
Sheikh Raja or something.
My lord?
Sheikh Raja or something.
Sheikh Raja. Huh.
No, yesterday you also said that
Yes,
this has been kept, the entire article has been seized.
Entire articles have been seized. So for that reason, to make it more clear, I have given the seizure list and the forwarding report. They had, my lord, initially issued this ballot ECIR bearing number BBZO 17 of 2022 under the provisions of PML Act. That is in the year 2022. But nothing was served to us. We were not known until the order of remand was passed. If my lord will see the judgment, I have the copies there. It will be seen that the court, they have categorically, Honorable Apex Court has categorically observed that you may not give it in pen and paper. But accused person should know what are the allegations for which they have been taken. But that is not there. And the submission of my learned senior is that they have not been taken as an accused before filing of the complaint. For that reason, specifically, he has mentioned, Madam may see the complaint petition, Annex 3, column 7. Accused persons have not been arrested under the provisions of 19 of PML Act.
Yesterday, yes.
Yes, that is there. And submission is, this complaint petition is after the cognizance.
But one thing that he has raised is that you have not been arrested actually, but you have been taken on remand. He is trying to make a
remand, if Malad will see the Madhulima's case.
They were already in bail. They were already in jail. Because they were already in jail, we asked the court to bring them in remand. That is the question.
So unless a person is in custody and to be as an accused, remand, they have prayed for remand. And when they have prayed for remand, and what would be the remand order of the remand order supposed to be passed by the session judge? That is there. 19.2, what would be the remand order? The language of the remand order should be what should weigh the mind of the court. Court is not a beca.
That is in the Bansal's case you are referring.
Yes. And that too, submission again.
It covers both arrest, physical arrest as well as remand.
No. While during arrest, if I arrest him under 19, then while sending him under remand, those things are there.
No.
That communication.
Yesterday.
But that communication is in October 2023 is to be followed. And this was prior to October. We had taken him prior to that judgment.
Yesterday, if I have understood my learned, senior properly, that he says.
Was the googly. Yesterday was the googly. Today is the.
Dusra. Is the Dusra.
Yesterday, my lord, I wanted to see.
It was only after.
My lord.
Time for a
My lord. My lordship would see.
It is very much there that he says after the cognizance order was passed, he has been taken as an accused and accordingly complaint petition has been filed or charge sheet has been filed. Yes, I think I have understood it properly.
Yes. Thank you. I'm obliged.
Then my lord, you just see the order sheet.
Summary. 11, paragraph 11.
Not 11. Order sheet of the court. That cognizance has been taken on 7/8/2023. Let me see.
Yes.
Complaint petition filed by the learned special PP ED on 4/8/2023.
He was presiding officer was on leave. So it took it on 7. It is written there. My lord should say the order. I want something.
If the order is 7/8, definitely if the version of a submission of my learned senior will be taken on its face value without adding or without subtracting anything, the complaint petition should have been filed after 7/8, not should have been.
Why?
You have said so.
No, I've never said so.
Well, I
think-
have given a short note.
Yes,
that's-
yes.
that's-
I have taken note
I
of
don't
all.
want to take more time and.
No, I have taken note.
Disturb my other friends.
No, actually, whatever you have, both of you have argued, I have taken note.
Right, yes.
That should be sufficient. Note of that. You have already filed a note.
I've already filed a note, but my argument which I've told my lordship today, when I'm not taking him when I'm not.
I have taken note of it. I have taken note of it.
Yes, then only 11 of my complaint. The complaint humbly submits that the evidence have been duly collected under the provision of the PMLA, under inter alia, including the collection of evidence during the custodial interrogation of the accused person to prove that all the conditions as stipulated under Section 3 of the PMLA Act, read with Section 2LU of the PMLA Act 2002, are wholly satisfied, and therefore we hereby take.
All right.
That is all.
Hearing concluded, order reserved, by judgment reserved.
Deeply obliged, my lords. I'm really.
I'm not
deeply
passing any order for filing of written note because I have already done that and he has also already done. Adjust karo.
And I'm giving another written note also.
If you want it.
Beyond record.
Yes. Item 30 of the. Item 30, yes.
ସରୋଜିନୀ ସେଠର
Last item. Do we have that deposition?
Oh, yeah.
That's already.
PW1, perhaps he has
Yes.
given that deposition copy of PW1.
PW1.
My lord, Debasis Jana, who was accompanied.
No, my name is Saurabh Chandra Panda. PW1.
PW1 is Debasis.
No, I have JGR number.
Perhaps you even hold the deposition copy so far other adult accused persons are concerned.
So these are probably
separate.
in the juvenile case. So JGR lekha hoichi na.
Separate trial.
Juvenile court re hochi to. Where did you say that?
Sorogen Seta, that deposition copy.
But that will be in the other case. No. So this is, which is this case? This is JGR case number 12 of
JGR case number 12
In that case, Sarojini has not been examined.
Has not been examined, lords.
Not been examined, but even that other, since the case is the same, the deposition in the original trial can be looked into.
That's correct, lords. If they have a Sarojini set of statement that can be supplied, lords.
You give a copy.
So my respectful submission have been granted, lords. This case was the first cause investigation by the general police. Later state it has been transferred to so far the CIDCB is concerned. So Sarojini said twice examined. Once before the general police, then second before the
crime branch.
Crime agents. And there is a differential lordship. First examination so far the general police 14/3/2022 and second examination so far the CIDCB 27/3/2022. So before the general police on 14/3/2022, 161 CRPC, so Sarin sir taken name of myself. I am one of the unlawful assembly. And so far the 27/3/2022 before the CIDCB has never been taken my name at all. It is a better investor has prayed for transport so far the CIDCB. So there my name is not taken in consideration. And apart from this, lordship is a application under section 12 of the juvenile justice. The paramount consideration so far consideration of the benefits like this, lordship. When any person who is apparently child and is alleged to have committed a bailable or non-bailable offences is apprehended or detained by the police or appears or brought before a board, sore person shall, notwithstanding anything contained in the code of criminal procedure or in any other law for the time in force, be released on bail with or without surety or placed under the supervision of the probation officer or under the care of any fit person. Provided that such person shall not be so released if there appears reasonable grounds for believing that the release is likely to bring that person into association with non-criminal or expose the said person or moral, physical or psychological danger, or the person released would defeat the ends of justice, and board shall record the reason for denying the bail and circumstances that lead to such decision. 2. When such person having been apprehended is not released on bail under subsection 1 by the officer in charge of the police station, such shall cause the person to be kept only in a observation room in such manner as may be prescribed until the person can be brought before the board. When such person is not released on bail under subsection 1 by the board, it shall make an order sending him to an observation room or a place of safety, or as the case may be, for such period during the pendency of the inquiry regarding the person as may be specified in the order. When a child in conflict with the law is unable to fulfill the condition of the bail order within the 7 days of the bail order, such child shall be produced before the board for modification of the condition of the bail. So this is the paramount constitutional lordship while considering the bail application so far the juvenile is
Is there a social, what do you call
social
it?
report, your lordship,
Social report.
investigation report, your lordship.
Yes,
There, my lord.
That has been
In,
called for, your lordship.
Last, last
Let me-
para.
Let me take a check.
No, I'm just asking, where is it, where is that social investigation report? Is it there on record?
This court, your lordship, earlier occasion has been called for to the social investigation report. I do not know whether they are in record or not, but he has been
Mr.
submitted.
Jana will do one thing. Let him first give him, let him first give you a copy of this Sarojini Seth's deposition. And secondly, let us find out whether there's a social investigation report. It must be there.
It is there in our record.
So you pass it on to the court.
It is there, my lord. Suggestion of child welfare police officer. He should be tried as an adult accused by the children's court since the offense.
Whatever may be, whatever may be.
And in nature and his age group.
No, you give a copy, and so that Mr. Jana can also respond. You give a copy of this, huh?
Social background.
As it appears, only 2 witnesses out of 69 have been examined in the court below, where the petitioner, being a juvenile, is being tried. Learned State Council, however, has a copy of the deposition of Sarojini Setha, who was examined as PW4 in the trial by the co-accused persons.
Now, those
That
are
copy the-
those are not juvenile lords.
Other trial of co-accused persons who are not juveniles. Let a copy of this deposition be served upon Sri Jana. The State Council is also directed to produce a copy of the social investigation report in respect of the petitioner for perusal. We'll take it up when?
Next week, lords.
All right, leave this matter next week. Serve a copy. ये बंद करते हो? हाँ. देखो. अब कोई नहीं इसलिए? हैं? और वह कहता है. No.
Item number 22.
Yes. My lord, in this case, I am through virtual mode. Lordship,
Yes.
in this matter, I am through virtual mode. Lordship, I am in JC since 25/9/2020. 3 year and 8 months of JC. Lordship, at the flag D, the learned trial court is there. Lordship, out of 3, 2 are already on the interim bail passed by my lord only on the last May 23. Lordship, as per my information, out of 16, only 5 charge-sheeted witness has been examined yet. Lordship had passed a direction last year in the month of August to finish this trial by the end of 23. But till now, the trial is lingering. And Lordship, there is sufficient material on record that this is a fit case to be released on bail, regular bail. The 2 independent witnesses have not supported the theory of alleged search and seizure. And I have annexed at the page number, Lordship, may kindly see 26. 26. And this is the judgment of Hon'Ble Supreme Court only on bail only, Lordship. And the act was the same act, NDPS Act. Lordship, page number 26, last 2 lines. Furthermore,
Where are you reading from? Where are you reading?
Lordship, the bail application, page number 26. Annexure 5.
Page 26.
Yes, Lordship. Annexure 5, last line, last line. Furthermore, prima facie having regard to the circumstances that the recovery witnesses relied upon in the prosecution has not supported it. The court is of the opinion that at this stage the petitioner ought to be released on bail. Accordingly, interim bail
Has been made
granted by
but here
the
huge quantity, my lord.
450 was there in this case, Jyoti Sira case. Lordship may kindly see the page number 29, para 4. It was also the case of same act, NDPS Act, and coordinate bench judgment was challenged. Para 4, Lordship, as regard the twin condition contained in section 37 of the NDPS Act, learned counsel for the state has been duly heard. Thus, the first condition stands satisfied. So far as the second condition to form an opinion as to whether there is a reasonable ground to believe that the petitioner is not guilty, the same may not be formed at this stage when he has already spent more than 3.5 years in custody. The prolonged incarceration generally militates against the most precious fundamental right guaranteed under Article 21 of Constitution of India.
Any co-accused has been granted interim bail in this case?
Yes, Lordship. I have annexed that order, Lordship. Lordship, I have annexed that order. It's on the page number 24. 24, Lordship.
Alok Biswas.
Alok Biswas was released. Yes, Lordship.
Alok Biswas is a outsider or a local person?
He is a local person. And Lordship, if we see two more points, if we
Local
see the
person,
case,
ma'am. He's a local. Yes, madam. He's a local person. You are an outsider. Yes, madam.
Yes, but my information says after interim bail, that person has not surrendered. That Alok Biswas has till now vanished, absconded, Lordship. So
how does it help you? He being a local has not appeared. Now you being a man of UP, already you furnish cash security of rupees 10 lakhs.
My lord, he is a-
Right, pura regular bill दे दी. I'll grant you regular bill. Nothing.
Lordship, Lordship, in the FIR, there is admission that 50 and 42 has not been.
I've heard you, Mr. Manohar. I've heard you. While you were arguing, I've seen the entire thing. Huge quantity. You are an outsider. Once I've already
Lordship,
rejected your bill application.
Lordship, not huge, 150. 150, Lordship, only.
Yes,
It's not a case of 150. 157.
157. 150 coupled with the fact that you are not from the state of Odisha. So once I release you, you will not stand up to trial. That is a very, very difficult situation that we are facing here in Odisha. 10,000 NDPS cases. And wherever bail has been granted.
My humble submission is that if my lord takes some view like the local person has been released on interim bail, at least he should be released on interim bail, although it's a case of regular bail. It's 3 years and 8 months of JC, and the trial is still lingering on. And two independent witnesses itself totally falsified the whole search and seizure. Then the whole prosecution story fails. And in FIR, they have admitted that they have not complied 40 to 50.
Right. As the court below has submitted a report stating that out of 14 charge sheeted witnesses, 5 have been examined so far. Further, the co-accused persons who were granted interim bail have not surrendered upon expiry of the period of interim bail. The court below is directed to transmit the copies of depositions of the witnesses examined so far. List this matter.
Deposition, I have filed, Lordship. Deposition is there in the record.
Where is it?
Lordship, is the page number 19 and 21. Page number 19. Lordship.
Okay, okay, all right. Sira kar de. Kar de. The co-accused persons, so those who were granted bail, they have,
They are local.
they are absconded.
My lord,
The
so
NBW has been
any
issued. No, no.
presumption that a local will come and outsider will not come, I don't think that is true. Since many local persons are not coming, but many outsider are coming.
This is
Last week I had
rare. This is really rare.
My lord, in the last week I had
No,
appeared
no,
in
no,
a
I will
matter
not, I will not grant you bail. I have heard you enough. Let this matter in the week commencing 8th July. Yes. Next matter.
Lordship, then any order may be passed. Then I will just humbly request to pass any order so that we may approach the top court.
Then I'll reject it. I'll reject
Yes,
it.
Lordship.
You better. All right.
Yes, Lordship.
That will be better actually. Instead of keeping it pending here, if he can get an order from the Supreme Court, well and good. The petitioner is in custody since
Lordship, since 25/9, 2020.
25/9/2020 in connection with such and such case. His earlier application for bail was rejected by this court by order dated 4/9/2023 as per order passed in BLAPL number 4558 of 2022. Stopping the said order, this court had also directed the court below to make all efforts to conclude the trial positively by the end of fourth quarter 2023, failing which it would be open to the petitioner to renew his prayer for bail. Since trial has not concluded within the stipulated period, the petitioner has renewed his prayer in the present bail application. The prosecution case is from the report submitted by the court below. It is seen that the co-accused persons, that trial has
Same as
not.
said, Lordship.
अगर टिक प्लीज आप थोड़ा 5 मिनट वेट करिए. मैं ऑर्डर पूरा डिक्टेट करने के बाद अगर आपको कुछ कहना है तो बेशक कहिए, मैं सुनूंगा, दिन भर सुनूंगा, बट बीच में प्लीज कृपया करके मत बोलिएगा.
Sorry.
कौन लिख लिया? Trial has not been able to progress because of abscondence of the co-accused persons who have been granted bail, who were released on interim bail. Be that as it may, the prosecution case against the petitioner is that he and 3 other persons were transporting contraband ganja on motorcycles weighing 157 kgs when they were apprehended by police. Stop. Taking note of the fact that the contraband was seized from the exclusive and conscious possession of the petitioner, which is also commercial quantity, which is also more than commercial quantity, this court was not inclined to allow the prayer for bail on the earlier occasion. Stop. Reliance has been placed on the evidence of 2 independent witnesses, 2 witnesses examined by the prosecution, who have not supported the case. One বন্ধ বিভার বিভালার না কোন স্পেলিংটা দেখি করবি. হ্যাঁ, না লিখুন তো. One Gautam Markami and Dulla Pariami were examined as PW 3 and 4. purporting to be independent witnesses, but they have not supported the prosecution case and have turned hostile. According to learned counsel for the petitioner, this falsifies the prosecution case entirely. This court is unable to accept such contention because the charge sheet lists as many as 14 witnesses to be examined. Though several official witnesses are cited as witnesses, it cannot be said that their version would be not worthy of belief, or that no reliance can be placed upon them. So, it is true that the petitioner has been in custody for nearly 4 years. But then, having regard to the 4 years, the State Council has vehemently opposed the prayer for bail on the ground that the petitioner does not belong to the state of Odisha, and therefore, if released, he may not attend the court during trial. Taking into consideration all the above facts, and particularly the fact that trial is in progress with several witnesses being yet to be examined, it would not be proper to release the petitioner on bail at this stage. The bail application is therefore rejected. The court below is, however, directed to take all possible steps to conclude the trial in respect of the petitioner positively within 3 months. It shall be open to the petitioner to renew his prayer if trial is not concluded within the aforesaid period. Yes.
I'm obliged, Lordship.
Yes. Anything else you are saying, Mr. Manohar? Something else?
No, Lordship, nothing.
All right. Yes.
I'm obliged.
Yes. Yes, what is this matter? 120B, 121 official secret
My lord,
shares.
this is the third round litigation before your lordship.
Yes.
On previous 2 occasions, your lordship has been pleased, though pleased not to allow final bail, but your lordship has been pleased to grant me interim bail on 2 occasions. And on both the occasions, the petitioners have surrendered in time and complied every condition that has been imposed. Now the petitioner is in custody since 14/9/2021.
Yes,
my lord.
Case diary is not obtain the case diary. Then let him get the case diary. All right. Up to the case diary be obtained. Place this matter in the week commencing vacation for SU. Week commencing 8 July.
Item 24.
Your Lordship, this is a petition under section 439 of CRPC. The alleged offences are under section 21C and 29 of the NDPS Act.
Yes.
The allegation is that the police seized about 4,000
Cup syrup.
Yes, madam.
800 gram codeine phosphate. Same order. Same order. Yes.
Item 25.
May I please? My lord, this is the second application of the petitioner, my lord. Earlier, lordship has been pleased to reject the bail application of the petitioner in bail appeal number 13557 of 2023. Case under section 307, 323, 506 and 341. Charge sheet has been submitted and the and the petitioner is inside custody since 15/9/2023. Looking into the nature of injury on the last occasion, Lordship was not inclined to release the petitioner on bail. But as per my instruction, the injury is quite hell and hearty, madam. No. At that time also, he was.
कौन सक्सेसिव बेल एप्लीकेशन कौन पे रिजेक्ट ହେଇଛି
Royal.
307 रे if I have rejected an application under 307 it means
15/9/2023
Trial is going on and rejection order shows that victim and
It has
have not been examined.
ଏଇଟା ହଉଛି ଆଜ୍ଞା injury.
no no ମୁଁ ଆର୍ଥର ଦେଖିକି ମୁଁ ପଢି ସାରିଲିଣି ଅର୍ଡରଟା we will do one thing you call for the case diary
Trial ଆରମ୍ଭ ହେଇନି ଆଜ୍ଞା. Trial ଆରମ୍ଭ ହେଇନି. Laceration injury ଅଛି.
Trial the complainant and the victim are yet to be examined.
Yes.
Rejection order.
ସେ ତ injury ଗୁଡାକ ସବୁ laceration.
no this suggests the intention I have referred to the intention.
Yes.
So you do one thing, you obtain the case diary.
Different parts of the body assault has been made.
The intention is very clear. Holding an axe,
Maybe.
assaulting.
Maybe.
Up-to-date case diary be obtained. Let this matter. Vacation per karo. Week commencing 8 July.
Item 26.
My lord, 20B2C, 152 kg, 550 grams. He is in custody since 2010-2022.
2010-2023. 22, yes.
22. And out of, my lord, 26 witnesses, only 5 witnesses have been examined. And the allegation is that on getting information that a huge quantity of ganja is being stored in the house of the present petitioner, the police party went there and found petitioner along with 3 others were stacking ganja in different gunny bags. So they arrested them, and since then he is in custody. He has no criminal antecedent, and he is in custody since 2010-2022, no criminal antecedent, and only out of 26 witnesses, only 5 have been examined.
152 kg,
My lord?
152 kg,
153 kg.
That is true, my lord. And keeping that in view, that trial has not progressed, your lordship was pleased to grant
interim
bail to 3 others.
Yes. You have not been granted interim bail.
No, I have never filed.
Well, then same order.
This is the order.
इतने कल लिखी हुई, इतने last लिखी हुई, ये ना, custody more than 1.5 years, more than 2 years ही गया in the meantime.
2 years in.
अच्छा, 1.5 years, and only 2 out of 26 witnesses, no, कितना क्वेश्चन 5.
5.
ये दरकार नहीं हमारा अच्छी.
आपन का order.
अच्छी. 5 witnesses, है ना?
Obliged.
6 weeks. जेते जाए जी 3 से.
6 weeks नुहे 3 मास देइछन बोले.
सेतरे?
आगो हां एक्सटेंशन हे कि जाइछ.
से एक्सटेंशन जा दिया ही से आओ.
3 मास देइथिले प्रथमे तापरे.
ना 3 मास तो नहीं.
हां देइछन आपन.
देखिए 3 मास लगला. लागला कि दिखला. 3 months अच्छी मैं जान पले नहीं. To release the petitioners on interim bail for a period of 6 weeks.
6 weeks जो एक्सटेंशन हे
So extension है वो नहीं जो.
10/4 रे पुनी एक्सटेंशन हे छि. प्रथमे 28/2 रे हितिला. पुनी 10/4 रे हे छि.
सेटा लास्ट हो.
नहीं तो आगुडे बदे.
आगुडे भी जेरी भूल के नहीं. ना आगुडे ही न थु देखि.
Then
10/4 पर के बेला.
10/4 हां 10/4 रे हे छि. फर्दर 4 weeks.
तापर
ता प्रथमटा हेतिला 6 weeks.
सेटा हला.
गोटे मिनिट. ठीक है. 6 weeks तापर 1 week 4 weeks. आ गोटे हे छि जो टिके देखि दी. नहीं रे 28/2 रे दी थरो हे छि. खाली एका बेले मते 2 मास दे दो नहीं. नहीं. एका कथा नहीं.
नहीं. हम सब हिसाब मिसामिसी करी सब हिसाब कला सब. एथरे करबे कि मना करते एथरे करबे. दी थरो 3 बेल को Yes.
hopeless.
Disposed of.
Same order disposed of.
Item 27. Here, my lord, regarding cultivation of a hemp plants, my lord.
In that other case also, that Mr. Mishra, in that other case also, bail could have been granted only because he is an outsider. Otherwise, I would have granted.
Local person, lordship granted, but
Yeah, that is the problem. Yes.
Here, my lord, regarding cultivation of a hemp plants, my lord. In the meantime, you will also be granted a bail to the other coerced person, those who are apprehended from the spot, my lord. And
Same order.
20,000 plant, government forest land.
Yes.
Item 28.
May I please, your lordship? Lordship, the offence is under section 302 34 IPC. In this case, the accused petitioner is in custody since 15/5/2023.
Achha, ye case diary. Who's the petitioner? What is the name of the petitioner? Tinku alias Sarvan Kumar. One Akash Patra.
Sir, Akash Patra is already enlarged on bail. Subsequently, another 2 accused persons also enlarged on bail.
From unknown person stopping on the way, severely assaulted him, causing bleeding to his statement of Ajit Sandal. Achha. What is the allegation against this?
Copy has not been served, my lord.
Oh.
May I permit, sir?
Yes.
My lord, on
No, you have not served copy. You have not served copy.
Sir, 4/4/2024 surveillance. I have received.
କେବେ ଦେଇଛନ୍ତି copy? 4/4
4/4/2024 received.
You do one thing. I'm passing it over. Tomorrow you find out.
Yes.
We'll take it up tomorrow. You have the case diary though.
No, my lord. First time it has come.
Case diary तो नहीं एकाथरे कौन करे ताले case diary मगे दो आपको. Will case diary काली की रखी लाभ कौन? You obtain that the copy of the bail application from your office. In the meantime, let me call for the case diary. Up to date case diary be obtained. List this matter. Vacation पर आसु. 8 July. आरो week तो last week ने ही जाऊँ ना almost.
I would a copy दे दिया तो mail. I would author पठे.
How you send another copy to the office of the Advocate General.
Sir.
Item 29.
This item is same as the item number 27, man. Cultivation of hemp plant.
That hemp plant, my lord, similar matter.
All right, same order.
Item 30.
I plead your lordship. Your lordship, I directed to call for the case diary, my lord. Last occasion.
Not case diary, your lordship directed.
The load of asbestos.
Yes, my lord.
I also directed.
As the
Two
petitioner
occasions your lordship was pleased to direct case diary, my lord. That is in record. But in fact, dispute in
कॉलेज से asbestos load तक.
present petitioner is a driver. He was driving. No, because of there was dispute in between employer and employee regarding only salary. Then this case is completely false and fabricated. When petitioner demanded his salary, previous salary, then first at this case.
Yes.
The investigation is going on. Till date, it has not been recovered, my lord.
You had gone to Fulbani.
Allegation is that, my lord.
I say allegation কথা पूछी.
But never gone to.
You find out some for the statements of some of the witnesses.
A consignment note is there. Already it has been loaded, my lord.
That is up to him, employer. Has not been loaded, has not.
GST invoice, consignment note.
Everything.
Everything is there.
So,
but petitioner has not, because of when demanded salary.
No, don't say that. Don't say that. Say something which is on record. That is your defense. That is your defense you are taking. That defense will be available at the time of trial. So we will look at the prima facie case, and prima facie there is no prima facie case against you. So that is why I have granted you opportunity to inform the court what happened to that load of asbestos, so that I can impose some cash security and leave you.
Your lordship may impose cash.
So cash security कितने थिला? लक्ष्य 60 ना कितने थिला देखले? मुझे मालूम पड़ा।
1.5 lakhs.
1.5 lakhs. है ना? दें cash security? कितने देवे?
As your lordship may.
क्या साहब?
Your lordship may fix.
10 লক্ষ
Your lordship fixed.
the petitioner is in custody since
No, not
my lord,
custody,
anticipatory.
এই anticipatory bail আছে
Yes.
মই জানি পারছি না the petitioner is apprehending arrest in connection with such and such case. The case of the prosecution is that the petitioner, being the driver of the informant, took a consignment of asbestos worth rupees 1.5 lakhs
Yes.
from Denkanal to Fulbani. Stop. It is alleged that the truck never reached Fulbani and was diverted to some other place. The vehicle was also not traced out, and there was no information about the driver. The truck was subsequently found parked at bypass square of Denkanal, but the load of asbestos was not was found missing. Stop. Sri Pradhan, Learned Counsel for the petitioner, submits that the case has been foisted falsely, as the petitioner demanded his arrear salary from the employer. Learned State Counsel opposes the prayer for anticipatory bail by submitting that there is prima facie proof of the truck being loaded with asbestos, which the petitioner, being the driver, is supposed to account for. Having considered the rival submissions and the nature of accusations, as also taking note of the fact that the investigating agency has not required the custodial interrogation of the petitioner, while not being inclined to grant anticipatory bail, the anticipatory bail application is disposed of. See, you surrender, release on bail. Condition kar debe. Cash security of rupees kete? 50,000. 50,000.
Item 31.
May I please, Your Lord? Informant is the injured after
You want
14
anticipatory bail
days,
na regular bail?
anticipatory bail.
ये क्या विषय की किंतु कोई ଏମିତି ହଉଛି ନାଇଁ ମୁଁ ତ ଲିଷ୍ଟ ଟାକୁ ନଜର ପଡୁନି ନା ସେଥିପାଇଁ it is creating sometimes confusion. Anyway, yes, Mr. Sahu, what is
Informant
this?
is the injured. 326 along with other offences. 14 days after FIR has been lodged and he was in custody. The injured is in custody. Offence under section 302, my lord. 302 re injured bhitre.
What co-accused has been granted first or second or? Ranjit
Injury
Kumar.
kichhi nahi, subject to verification of
Ranjit
injury.
Kumar Rai.
Grievous injury is there, sir. Deep lacerated wound on parietal
See,
region.
yaar allegation nahi.
Brass
Injured has
injury
not
on both
stated. He is in custody. my
ପ୍ରଥମେ କହିଲେ ଇଞ୍ଜୁରି ନାହିଁ ତାପରେ ଯେତେବେଳେ ଇଞ୍ଜୁରି ହେଲା କହିଲେ ୟା ନାଁରେ ନାହିଁ ନାଇଁ ମୁଁ ଯାହା ଆପଣ କହିଲେ ମୁଁ ଯାହା ଶୁଣିଲି
Injured is concerned, my lord. Now he is in custody, my lord, under section 302. That apart, my lord.
So how does it improve your case? He may be in custody in 302. How does it help your case?
What happened, my lord? There is a dispute between two brothers, my lord. It is alleged that the informant stated that he is another brother, congregated all the accused person and giving liquor and assaulted the informant, my lord.
ୟା ନାଁରେ କିଛି ନାହିଁ ମାନେ ଆଉ କାହା ନାଁରେ ଅଛି ଦେଖିଆ
Injured statement.
ଆପଣଙ୍କ ନାଁ କଣ?
ଧରଣୀ
ଧର ବିଶ୍ୱଜିତ ରାୟ ଗଙ୍ଗାଧର ରାୟ ୟାଙ୍କ ନାଁରେ କଣ ଅଛି? ନାଇଁ ବାହାରିକି ରୁହନ୍ତୁ
Statement is there, my lord.
ନାଇଁ ରୁହନ୍ତୁ ଆଗ ଏଫଆଇଆର ଟା ଦେଖୁନାହାନ୍ତି 14/6/2023 ତାରିଖ 12:30 ଆଦିବାସୀ ସାହି ଗଙ୍ଗାଧର ନାୟକ ପିତାଙ୍କ
ଘରଠାରୁ
ମୁଁ ଥିଲି ମୋର
ବଡ ଭାଇ ବାହାର ଲୋକ ଆଣି ସେଇ ଆଦିବାସୀ ସାହିର ପିଲା ବାଟି ନାୟକ ପୁଅ ବାବାଜୀ ନାୟକ ଶିବ ନାୟକର ପୁଅ ରାଜା ନାୟକକୁ ମଦ ଦେଇ ତାଙ୍କ ସାହିରେ ମୋ ସହିତରେ ପ୍ରଥମରେ ଗଣ୍ଡଗୋଳ କଲେ। ତାପରେ ବାଟି ନାୟକ ମୋ ବେକ ଧରି ତାଙ୍କ ପାଖରୁ ବାହାର କରି ଆସିଲେ। ତାପରେ ମୁଁ ଘରକୁ ଫେରିଲା ବେଳକୁ ମୋର ବାପା ରୋଡ ପାଖରେ ଛିଡା ହୋଇଥିଲେ। ମୁଁ ତାଙ୍କ ସାଥିରେ ଘରକୁ ଆସିଲି। ମୋର ଦାଣ୍ଡ ପିଣ୍ଡାରେ ବେଞ୍ଚ ଉପରେ ଶୋଇ ପଡିଥିଲି। ରାତ୍ର 2:30 ମୋର ଭାଇ 7-8 ଜଣ ଲୋକଙ୍କୁ ମେଳ କରି ଆଣି ପ୍ରଶାନ୍ତ ବରାଳ ପିତା ଧୋବା ବରାଳ, କାଶୀ ବରାଳ ପିତା କୁଳମଣି ବରାଳ, ଧରଣୀଧର ବରାଳ ପିତା ତାରେଶ୍ୱର ବରାଳ,
ସୁନୀଲ
ବରାଳ ଅନିଲ ବରାଳ ପିତା ପଞ୍ଚୁ ବରାଳ, ଛାମୁଣ୍ଡିଆ ପଲ୍ଲୀ ଏବଂ ପ୍ରଶାନ୍ତ ବରାଳ ଶଳା 2 ଜଣ, ଜଗା ଓ ବଳିଆ ଏଇମାନେ ମୋର ଭାଇଙ୍କ ଠାରୁ ମଦ ପିଇ ଏକତ୍ରିତ ହୋଇ ମୋର ଦାଣ୍ଡ ଦୁଆରେ ଶୋଇବା ଅବସ୍ଥାରେ ହାମର ଭୁଜାଲରେ ମୋ ମୁଣ୍ଡକୁ ଚୋଟ ପକାଇଲେ।
Next is allegation.
ମୋର ଭାଇ ଏବଂ ପ୍ରଶାନ୍ତ ବରାଳ 2 ଗୋଡ଼ ଭାଙ୍ଗି ଲେ। କାଶୀ ବରାଳ ଧରଣୀ ବରାଳ ମୁଣ୍ଡକୁ ପିଠିକୁ ଚୋଟ ପକାଇଲେ। ମୁଁ ମରିଗଲି ହେଲା ବେଳକୁ ବାପ ଘରୁ ବାହାରି ଆସିଲେ ବେଳକୁ କାଶୀ ବରାଳ ବାରିପଟେ ସମସ୍ତେ ଦୌଡ଼ି ପଳାଇଲେ। ରିପୋର୍ଟ ଲର୍ଡସିପ କାଇଣ୍ଡଲି ସି କଷ୍ଟଡି ପଳେଇବ। ଇଏ ଲର୍ଡସିପ କାଇଣ୍ଡଲି ସି ଦ ଇଞ୍ଜୁରି
କଷ୍ଟଡି କଲେ ଯିବ ରେଗୁଲାର ବେଲ ତାପରେ ମୁଭ କରିବ କଷ୍ଟଡି
ମୁଣ୍ଡକୁ ଚୋଟ ପକେଇଲେ ପ୍ୟାରିଟାଲ ରିଜନ injury is there.
କାହିଁ ସେ ଇଞ୍ଜୁରି ରିପୋର୍ଟ ଦେଖୁଛୁ ଦେଖିବା if it helps.
Grievous injury.
14 ଦିନ ପରେ ଏଫଆଇଆର ଦେଇଛି। ସେ ସମସ୍ତେ ଙ୍କୁ
deep lacerated wound 5 cm on parietal region. Crush injury on both legs ଟା ଛାଡି ଦିଅନ୍ତୁ କିନ୍ତୁ ଏଇ ଯୋଉ parietal region
14 ଦିନ ପରେ ଆସିଲା ପରେ ଆଜ୍ଞା ଇଏ କରି ଲର୍ଡସିପ ରିପିଟ୍ ଆଫ୍ଟର ଭ୍ୟାକେସନ ଆସୁ ଆଫ୍ଟର ଭ୍ୟାକେସନ ଛୁଟି ଅଛି
ଛୁଟିଟା ଅଛି କଣ
ଆଫ୍ଟର ଭ୍ୟାକେସନ ଆସୁ ସେ ଦେଖିଦେବି ଚାର୍ଜସିଟ୍ ହେଲାଣି କଣ କି ପିଟୁ ଆଫ୍ଟର ଭ୍ୟାକେସନ
ଏତେ ସମୟ ନଷ୍ଟ କଲେ ଆପଣ Leave this matter after vacation as paid for.
Interim order to Martin.
Leave this matter on reopening the court. 24th June. Interim order shall continue till then.
Case 307 other offences. There is omnibus allegation also.
Ishwar Jana.
First of second of party.
Judge
Case first or second.
Same order.
Yes.
Item 33.
Listeners are implicated under section 307 along with other offences, my lord. The case arises out of complaint case, my lord. Both the complainant and accused persons are belongs to one family members, my lord. Due to land dispute, this case has been posted, my lord.
One of the co-accused has been granted bail.
Yes.
No, either juvenile has been granted bail.
Juvenile, last order, your lordship has reflected that allegation against Nayana Pradhan,
Yes.
that petition number 2, my lord.
No injury at all, my lord, as per my instruction.
Injury report?
Injury report first.
Oh.
Press matter, my lord.
Case data along with injury report to be obtained. List this matter on 24th June. And in the week commencing, week commencing 24th June. No coercive action till then.
Item 34.
34, my lord. Bail application in respect of the petition number 2 may be not pressed.
Petition number 2 not pressed?
Yes, madam.
Bail application in respect of petition number 2 is not pressed.
Petition number 1 is concerned, lordship already.
Some of the co-accused, your lordship granted first or
are
second.
giving the copy.
That Lakshman and the Saraswati, that matter.
Same order can be passed?
Yes, ma'am.
ये खाली जो केस डायरी नहीं से तो कर दो बोल
Item 35.
Actually, my lord, 307-149 IP challenge other offense, co-accused person dispose of bail application, surrendering.
राजकुमार राय
Yes, ma'am.
ना तो अच्छा
If the injury found to be simple in nature, that order is there.
yes same order
Similar. Item number 36.
Lordship, item 36, anticipatory bail, SC Act is there.
notice has to go
Pramod Rai and
Pramod Rai sorry
Anticipatory bail.
anticipatory bail देखो ना प्रमोद राय कर दो
Yes.
कौन ऑफेंस कौन
506.
ये प्रमोद
945.
normal प्रमोद राय
Yes. Item 37.
May I please? 365 and other alleged offense, petitioners and the victim already.
where is Mr. Ponda why is he not coming to the court is he coming to the court I have not seen him for long yes
365 and other alleged offense, petitioners and the victim already married, my lord, annexed to page 12, the marriage.
you are the main accused
Yes,
My
principal accused. The
No,
co-accused
yeah, co-accused also-
in kidnapping.
co-accused also you had obtained instruction that they had married
Yes, in that order it has been replaced.
yes the petitioner is in custody since
Like the anticipated.
sorry the petitioner is apprehending arrest in connection with such and such case. It is alleged that he kidnapped the daughter of the informant. Is she a minor?
No.
17 years? No, it is 17 years. How can we
26
accept?
11/2005.
Huh?
26 11/2005.
No. How come this marriage registration is good? 26/11/2005 but how do we know? Is this, do you have the statement of the victim?
No, my lord, first time.
Let the statement come.
Yes. Statement whether it has been recorded or not.
I will protect you. Let the statement come. Case diary be obtained. List this matter in the week commencing.
First basis.
1st July. No course of action.
Item 38.
Item number 38, my lord. This is a case of 20B2C, my lord. In this case, my lord, the petitioner is the owner of the motorcycle in which the so-called ganja is being transported, my lord. And apart from that, there is no other allegation against the petitioner, my lord. And in the meanwhile, the charge sheet has also been submitted, my lord. And all other co-accused persons are already been released on bail, my lord.
Yes. What is the matter against him?
My lord, he was not
Transporting contraband
charged,
ganja.
but subsequently
He-
charge sheet
he
has
is
been
the-
filed.
My lord, he is the owner of the vehicle wherein the ganja has been transported, my lord.
Okay, so he is not. He was not in possession.
No, my lord, he is not in the position when the ganja is seized.
I don't. Is the owner of the vehicle that you don't have any instruction.
All right. The
But not
petitioner
named in the affair, subsequently he has been charged.
Subsequently,
petitioner is apprehending arrest in connection with such and such case. The prosecution case is that some persons who are transporting contraband ganja. In a motorcycle?
My lord, motorcycle.
In a motorcycle.
Hero Honda deluxe motorcycle.
When they were apprehended by police. The petitioner is not named in the FIR, but charge sheet was submitted against him as he happens to be the owner of the motorcycle. Stop. There is no evidence to show that he was present at the spot or was in possession of contraband ganja. Where are you, from where, which place are you
Both.
appearing?
From both, my lord.
You are not appearing through the virtual court?
My lord, due to health reason, I am appearing from chamber, my
All
lord.
right. No, all right, all right. That is why I thought, why is he not appearing through virtual? Yeah, it's all right. No problem. Contraband ganja. The co-accused, similarly situated, has been granted bail, has been granted liberty to surrender before the court below with direction to be released on bail. Stop. In such view of the matter, considering the nature of accusations and the materials on record, see, surrender, release on bail.
Obliged, my lord.
Item 39.
May I please, your lordship? Lordship, the main accused in this case has already been released on bail by the bill number 1267.
Only Kanta Boralo.
My lord,
Only Kanta Boralo.
my
Same order.
Same order. Item 40.
Obliged.
May I please, lordship? Lordship, in this case, initially FIR has been lodged against present petitioner, the 392 IPC, lordship. After that, case has been turned to 395 IPC, lordship. In this case, lordship, present petitioner name, as per FIR, present petitioner name is not there, lordship. As per co-accused statement, he has been entangled in the case, lordship.
Yes.
One Sudham who has been named in the affair, he has been granted bail by imposing 50,000 cash settlement. But petitioner is not named, my lord. So
Case diary we obtained. List this matter in the week commencing
1st July.
1st July, no course of action.
Okay.
Item 41, urgent bail application.
May I be judged? My lord, last occasion, my lord has called for a report from the learned trial court, my lord. Here is a case, my lord. It's a excise case, my lord.
Here I go correction about it. The date of adjournment has been inadvertently typed as 6th April instead of 6th May. I'm order to put to the correction for that. Corrections be made accordingly. Yes.
My lord, it's a excise case, my lord.
Excise
Out of
case.
3 witnesses, till that, my lord, 2 witnesses has been examined. The petitioner is in custody since 5/8/2022. Total 126 kg of ganja was seized from the truck, my lord. And my lord, last occasion I have prayed for interim bail.
ଦି ଜଣ ପରା ସାକ୍ଷୀ ହେଲେଣି ଆଉ ଜଣେ ସାକ୍ଷୀ ଅଛି ଆଉ କଣ?
And the IO is not turning.
Already you have
IO has not turning off.
the court below has submitted a report that report stating that 2 out of 3 charge sheet 2 out of 3 PR witnesses have been examined so far. Learned counsel for the petitioner submits that only the IO remains to be examined. Yeah, but because of his non-appearance, the case is unable. The case is not moving further. The prosecution case is that the petitioner and another person,
Yeah.
were transporting.
Yes. In a truck.
Were transporting contraband ganja weighing
126 kg.
126 kgs when they were apprehended by. Is the petitioner or Olga?
No, Olga.
When they were apprehended by the excise officials. Considering the nature of allegations and the materials on record and the fact that it is submitted that the petitioner is in custody since
5/8/2022.
5/8/2022, and because of such long detention, several problems have arisen, which require in his family, which requires his personal attention. He therefore prays for grant of interim bail. He therefore prays for grant of at least interim bail for some period. Considering the submissions as above, and the fact that trial is at the fag end, while not being inclined to grant regular bail, the bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 4 weeks. Each the appearance.
Item 42. May I please, Your Lordship. This is the allegation under section 420, 467, 468, 471 IPC, 456 of Price, Cheat and Money Circulation Banning Act, and 6 of OPID.
You have to take instructions, specific role played by the petitioner. What is the allegation?
Allegation one betting app was created as 18football.com. On various schemes, money was collected with an assurance to pay high return. Thereafter, the main allegation is at para 16.13.
I'm reading out that.
In charge sheet. 16.13 charge.
16.13.
It is
What is the name of the petitioner? Ustam Khan.
Sir, they are Ustam Khan and Hakim, Mohammed Hakim.
Acha.
Two petitioners, sir.
They are in custody for more than one.
The directors of Hakim and Ustam Khan, both are Ustam Khan.
They have opened a shell company and with that process, utilize their account in 18football.com, providing the link. That link we provided to the investor to make deposit in that link. And that link belongs to that petitioner's company account. By this process, 11 crores 37 lakhs has been deposited in their account. Both are authorized signatories of that account.
Deposited from their in their account, but by whose money is that?
Investors, depositors. Their account has been utilized in 18football.com link. If anybody will deposit that amount, it will go to directly account of the petitioners. And I have seized the bank statement. Lordship will see only within 4 days, 11 crores has been credited.
Yeah, what is that app?
App is for a betting app, 18football.com. Betting app was created by some accused persons.
George Enjo, he was operating this.
That account. And a scheme is provided how to play the betting app. In the morning, that scheme will be circulated among the depositors. And the playing is compulsory. Every day they will play betting it. By that process, an assured amount will be given and the brochures are seized also by the IO.
Yeah, but where is the illegality? What is the illegality committed? I want to understand the case.
And they have provided brochure that will be giving the specific benefits.
Where is that? You have a copy of that brochure?
Brochures have been seized by the.
Sai, go to copy do na. Dekhe bujhiwa jinsa ra korte bujhiwa darkar na. FIR do na. Therefore, the FIR upon officer file very difficult. That's why we do. Let us understand what is the. It you have stated, of course, in the charge sheet you have stated in detail.
Charge sheet in
Several accused persons are there.
16.2 procedures.
Ramchandra Pradhan and others who have joined one app, namely 18football.com.
Through that app, 506 crore have been collected.
So it cannot be equated with a Ponzi scheme because it depends
No,
on.
it is different, not.
It is not a Ponzi scheme. So whoever invests, he takes that risk.
No, that is not, they are provided to give a specific benefits, not risks. It is not like a share market or any. Lordship may see para 16.2 of the class. Details are there.
Binance app wallet. Recently, I have dealt with a case of cryptocurrency. Where I have granted bail. That is, of course, different. This is different.
16.2. That's it.
No, other than this, have you obtained any further instruction about the specific role of the
Specific
specific role played by the petitioners and their personal liability, if
Yes,
any,
sir.
to the investors?
16.13, that 11 personal liabilities, 11 crore 37 lakhs.
No. Simply by saying 11 crores, how do we know?
Because in their account, the money has been credited.
କିଏ ସେ ଟଙ୍କା ତାଙ୍କ କାହା account ରୁ ଟଙ୍କା it could be a legal transaction also. So you, for the court to accept your contention, you must show from whose account the money has traveled.
Directly from the depositors.
Who are the
ଟିକେ difficult ହଉଛି ବୁଝିବା ପାଇଁ.
Their account has been utilized for the deposit of the depositors. The accused persons have utilized various accounts of about 12 to 15 companies' account, and petitioner's company was one of them. They have collected 506 crores, and 11 crores has been collected through the account of the present petitioners. They have provided a link to the depositors to make
That what you are saying is that they had offered higher returns and other benefits. Where is that? You have any document to show?
This document seized and also mentioned in the charge sheet.
Produce that document. Let the court understand.
I will produce.
Let the court understand. Kali, tomorrow?
after vacation?
After vacation, all right. All right. The state council, Sri Naik, Learned Counsel for the State and OPID Matters, submits that the query posed by this court on the earlier occasion is dealt with under paragraph 6.13 and 6.14 of the charge sheet. So
16.13.
16.13 and 16.14. This court would like to know as to on what basis it is alleged that the petitioners were alluring the investors to deposit money in the app in question on the promise of higher returns. If any such brochure or leaflet is available with the prosecution, same be produced before the court. List this matter after vacation of date.
So we commencing 1st July.
1st July. Yes.
Item 43.
May I please, Your Lordship? Here in this case, my lord, custody near about 1 year. Highest offense is 354B, my lord. And last occasion, Your Lordship,
will be fair.
FIR daughter laws and affair initially against father, my lord. 376.
Yes, I remember.
Yes, my lord. When he was granted bail on the behest of mother, again another affair has been lost, 354 case, and 35/2023, near about 1 year he is in custody.
On the last occasion, I remember Mr. Sahu, I was not
at best 5 years 354B.
ବର୍ଷେ ରହିଲାଣି consider.
I remember this case
Yes.
very vividly.
That connected record has come, my lord. Your lordship kindly see. When he was granted bail in 376, my lord, on the behest of mother, another FIR has been lost.
You may say on behest of mother, but FIR is an FIR. Making such allegation.
354B. Conviction for
making
5 years, my lord.
Sir, doctor making an allegation against the father.
Group 376, initially 376 allegation is there against father. And when he was granted 376 bail, my lord, this FIR.
Because he committed such act.
And he also
ବର୍ଷେ
threatened to
ରହିଲାଣି
the case.
କହିଥିଲା କିଛି ଦିନ ରହୁ ବୋଲି ଆସିଲା ଆଜି
ଆଉ କିଛି ଦିନ ରହୁ ପ୍ଲିଜ ଦିସ୍ ମ୍ୟାଟର ଆଫ୍ଟର ଭ୍ୟାକେସନ
20 ତାରିଖ ଦିନ ଆସୁ
ଆଫ୍ଟର ଭ୍ୟାକେସନ ଦେଖିଆ
ଆଫ୍ଟର ଭ୍ୟାକେସନ କେସ୍ ସରିଯାଇଥିବ
ନାଇଁ ସରିଯାଇଥିବ
ଆଜ୍ଞା ଆସୁ ଲାଷ୍ଟ ଭ୍ୟାକେସନ ଦିନ ଆସୁ ବର୍ଷେ ରହିଲାଣି ଆଜ୍ଞା
ହଉ this person does not deserve to come out.
376 allegation
whatever that girl has written, my God.
In Barampur area, your lordship knows.
How do I know? For me, it's a size one.
ଆପଣ ଥିଲେ district judge
ଗଲା
ଆସୁ 20 ତାରିଖ
କୋଉ 20 ତାରିଖ ଭିତରେ ଆସୁ ରିଓପନିଂ ଡେ ଆସୁ ଦେଖିଆ ରିଓପନିଂ ରେ ଆସୁ ଦେଖିଆ ୟେସ୍
18th
ଯୋଉଟା ହବନି ଯୋଉଟା ହବ
5 ବର୍ଷ ପନିଶମେଣ୍ଟ ବର୍ଷେ ରହିଲାଣି କନଭିକ୍ସନ
ହବ ଯୋଉଟା ହବନି
18 ତାରିଖ ଦିନ ଆସୁ ତାହେଲେ
ନା ଭ୍ୟାକେସନ ପରେ ୟେସ୍
ହଁ ଭ୍ୟାକେସନ ପରେ ଜୁନ 18 ପରେ କହୁଛି ରିଓପନିଂ
ମୁଁ କଣ ରିଓପନିଂ ମୁଁ 24 ବୋଲି ସବୁ କରୁଛି
ନାଇଁ 18 ତାରିଖ ଏଇଟା ବା
ହଁ କରିଦଉ ନା 18 କରିଦଉ
ଗୁବଲେଜ
Item 44 ମାନେ permitted to withdraw with the liberty to move afresh for the long time.
Yes. Permitted to withdraw with liberty to renew his prayer before the court below.
Item 45.
Please, your lordship. Lord, here in this case, the petitioner number 1 was granted interim bail for a period of 3 months, my lord.
Yes.
As he has been diagnosed with cancer on left buccal mucosa. And he surrendered in due time, my lord. In that surrender certificate also, the case was fixed to 25th April for consideration of charge. As per my instruction, till that charge has not been.
25 for each with what a date of now. What do you want now?
And the actor vacation as. And so far as my instruction, my lord, in that prison, my lord, co-prisoners are not staying with the petitioner number 1 who is suffering from cancer. As bad smell is coming out of his mouth, my lord. Operation upon the chemotherapy cells.
So what do you want? I have granted him interim bail.
Man.
You can still grant him interim bail. What do you want?
Interim bail.
Interim bail when did where is the surrender certificate?
21/12/23 for 3 months. Then on 27/3 he has to file surrender certificate.
Yeah, the surrender certificate has been filed. He surrendered on 27/3. So, looking at his condition, we can release him.
Yes, his condition is also very bad.
Leonard, the petitioner is in custody since
30/12/22
in connection with such and such case. It is alleged that the petitioner was involved in killing. This is no Nakono. The prosecution case is that an unknown dead body was found in a decomposed state in a jungle. Getting the information a UD case was registered by police and investigation was taken up. In course of investigation, the complicity of the petitioner came to light, for which he was taken to custody. What is the allegation against him?
Lord, he along with two others, my lord, the petitioner number one, he has stated everything under in his statement recorded under
Petitioner
27 Evidence Act, my. That
It is alleged that the petitioners, the petitioner,
Two petitions are there, your lordship may grant.
only petitioner number one.
one.
তাহলে এত কথা কেন লিখিও? লিখে দেবো, কাটো। I will reject it in case of petition number 2. I will grant it in case of petition number 2. লিখুন। হ্যাঁ না? যা ছিল সেটা চলবে। It is alleged it was found that the petitioners had conspired to kill the deceased, who belongs to the state of Uttar Pradesh. After killing him, they threw the dead body into the forest with the intention of concealing it. Stop. Looking at the overwhelming evidence on record, this court is ordinarily not inclined to grant the prayer for bail. Stop. However, insofar as petitioner number 1 is concerned, having regard to the fact that he is suffering from cancer and is under treatment, I am willing to take a lenient view. More so as he being granted interim bail earlier has surrendered to custody. In time. Stop. The bail application in respect of petition number 1 is therefore allowed purely on humanitarian reasons, purely on humanitarian grounds. Let him be released on such terms and conditions as the court below may deem fit and proper to impose. Next, the bail application in respect of petitioner number 2 stands rejected.
Item 46. Item 46. JMFC Nimapada, GR case number 733 of 23. My lord, custody dated 24/2023 under section 341, 450, 323, 354B, 506, 376, my lordship. Victim is
The treating doctor has also advised for better treatment in higher institution. The IA as Director and State Council has taken instructions, has obtained instructions with regard to the medical documents attached to the IA. It is stated that the document is genuine and that the petitioner's mother is suffering from geriatric diseases since few years and is under medication at DHH Phulwani. So further, the treating doctor has also advised for better treatment in any higher institution. Having regard to the above facts, I am inclined to take a lenient view. Let the petitioner be released on interim bail for a period of 2 months. List the main bail application for hearing in the week commencing 15 July.
2 months election 15 July.
That's happening.
Yes.
Lordship, item 2 that IA has posted for today, Lordship directed that.
Wait. Yes. So this will come in 15th July. Yes, right? Yes, Mr. Padi.
Lord, in item 2, my lord.
Item 2 of the weekly list.
Yes, my lord. I have filed the IA that was not came with Lordship's file. Lordship has directed to Peskar
কালি কইছিলি হ্যাঁ
again.
আনিছেন দেখলে আইএটা আইএটা আসেনি সে বুঝে বুঝি
কালি কি
কইছিল আইএ গোটে ফাইল করছেন নম্বরটা সে দিয়েছিল সে নম্বরটা কেতে কোন
43 IA 463 of 2024.
IA 463 of 2024. It will come tomorrow.
Yes, my lord. Again.
Yes, Mr. Panda.
Well, it's that interim bill in item number 7, in which the petitioner was supposed to go to the SCB Medical Collegiate Hospital for further.
No, they have given a date in the
Because of the fact that the MRI at the SCB will take some time. Therefore, I had requested my lords, in the event if your lordship will grant us interim bill, then we'll take him to a private hospital and get done. It's a varicose vein surgery which requires, my lords. And that is apparent from the medical report.
How much time would it require for surgery?
As far as the attendant who had been pursuant to a lordship order, we were told that not more than 16 to 20 weeks will be required for recovery, for which I had filed another IA. Since my first prayer in the IA was only for 6 weeks. Therefore, you're subject to your lordship's indulgence, my lords.
Yes, what you say?
My dear lordship may grant him 1 month bail. Then after he has to file a certificate from the doctor. That
Not 1 month, 15 days. Not 1 month. This person is only creating situations to be released on an interim bail.
But
My lords, the very fact that the varicose vein surgery is
Root canal. Root canal.
That is very well apparent, your lordship. I have never violated anything.
No, you are not violated. I'm not saying that you are violated.
Subject to the strenuous conditions.
Caesar the criminal to violate.
No, my lords.
All serious top hardened criminals, they respect the law in their own way.
With due respect, my lords.
Yes. That is how they function. One can
probably
report of the medical SCB medical.
My lord, this
Where is it?
report.
You had given yesterday. Oh,
Lordship may pass this order today, but it will be effected from 21.
With effective.
as directed. Learned State Council submits the report of the medical officer from a special jail, Bonaigarh. Bonai to? Bonai. Stating therein that the petitioner was sent to SCB Medical College and Hospital for his further treatment on 30/4/2024, with the information being forwarded to his family members about his treatment. Family members, stop. He has been given a further date for additional investigation on 5/8/2024, following which his further treatment will be planned accordingly. The certain certain documents, certain related documents are enclosed to the letter. Copy of this letter, the State Council is directed to submit a copy of this letter, which will be kept on record. Stop. Sri Ponda, Learned Counsel, S. Ponda, Learned Counsel for the petitioner submits.
May write my learned senior name because of the fact that now the people are looking through the VC. That is the only predicament. That is why he was here.
So that is why I am writing. If somebody is watching through the video or the virtual mode, he will see that Mr. Sudipta Ponda is arguing, not Mr. Devashish Ponda. So why should I write Mr. Devashish Ponda's name? He has earned enough name. He has earned enough name. So it is you should, yesterday I suggested that you don't appear, send Mr. Ponda. That is what I told him.
Yes, but I was assisting him in the death reference.
I know. He is required more there. Anyway, heard Sri Ponda.
item 46 auto advocate to matter more matter mention Suresh more power.
ଗୋଟେ କେସରେ ଅର୍ଡରଟା ଡାକୁଛି ଆଜ୍ଞା ମୁଁ ସାରେ Shri Ponda, no, Shri Ponda, learned counsel for the petitioner submits that in view of the date of additional investigation being fixed in the month of August, it would be unjustified to deny the petitioner his right of being treated in any other facility, in any other hospital, since he is suffering, he is in discomfort and pain and constant pain. Stop. Learned State Council submits that if such treatment is available in the premier health institute of the country, of the state, that is SCB MCH, there is no reason why the petitioner should be allowed to be, the petitioner should be released for being treated in any other hospital. There seems to be no dispute that the petitioner is suffering from a problem relating to varicose veins, which requires surgery. Stop. The report of the medical officer addressed to the State Council does not clearly indicate as to when the surgery is likely to take place. All that has been said is that future treatment, further treatment would be planned after additional investigation, and that too in the month of August 2024. This court does not consider this to be sufficient, to be specific information. Stop. That there is some force in the submission of Sri Ponda that a person who is in pain and discomfort cannot be deprived of his right of being treated in the place of his choice. Taking into consideration all the above facts and purely on humanitarian grounds, this court is inclined to take a lenient view. Stop. The IA is allowed. Let the petitioner be released on interim bail for a period of 4 weeks. 4 weeks. On such terms and conditions as the court below may deem fit and proper to impose, including the condition that he shall appear before the IAC of Kothana,
Plant
Site Police Station, Rourkela, every day at
the only predicament will be if I am traveling to Apollo, Bhubaneswar or somewhere.
that I will mention, don't worry, I will mention. Every day.
Only once if you
Every day at 10 a.m. And in case he is required to move out of Rourkela for treatment, he shall furnish his live location along with contact address and telephone number. The live location has to be given.
I will verify if he is
Live location to dabo, live location. Live location mobile time nathi bhai yahan. It's the top criminal scene.
Bear with me because during the root canal also your lordship had fixed those conditions.
But that was in Rourkela.
There was in Rourkela and there has been no violation. And my lords, your lordship, in that aspect only, I have surrendered on the right time on right occasions, my lords. If your lordship will see to my predicament, my lords, that way if your lordship will kindly bear with that fact that I will appear once in a week and
All
I
at
will
once.
furnish my details.
All at once in a week. Once
I'll
in a week.
furnish-
If whenever he is required to move out, he shall. Hala.
Contact address and telephone number.
Further, on each date of he shall in case he is outside Raurkela, he shall intimate the IO over phone every day at 10 a.m. of his whereabouts. Every day he has to phone and say that I am here. Further, on his surrender, he shall furnish all necessary proof of the treatment undergone by him in the meantime. He shall appear before the court below on each date of posting of the case, except when he is required to. Each date of posting of the case को छाड़ दूँ, बल्कि सही दिनों को पके दो.
खाली आईओ जगह आईएसी যদি প্ল্যান্ট সেট হবে কেন আইও তো অবিকা ট্রান্সফার
IAC.
That's
Corrected.
that document will be kept in record.
List this matter on. आगे लिखो तो this order shall be given effect to on and from 21st May 2024.
The order may be also communicated to the court below that way. Something like that.
This order be communicated to the court below. Next लिखो तो list this matter on in the week commencing 18th June. Alright?
But the date of surrender will be fixed by the court below in that event.
Why?
Because 21st then.
चल कर दो 24th June कर दो. 24th June करते ठीक है.
Okay.
In the meantime, so what is the study?
Okay.
Hello. Now, is there any other difficulty?
No, I believe my purpose is solved in that way.
No, because it may take some time to arrange securities to be released, and then
also
again
the funds for my private treatment. That is.
Be rest assured, he may be putting up a long face when it comes to paying professional fees, but otherwise, I mean, from the 21st of May, 24th of June, the list of. We can bring it in the supplementary list also.
Okay.
We can bring it in the supplementary list. I hope and trust that this is a bona fide.
My lord.
Because if he makes an attempt to
No, my lord,
just
that
take
will
it up
never-
to the last moment and then again come for extension, I am going to reject it.
No, my lords, that way it will never be, my lords, because my lords, we are also commencing with the trial also at the.
And you are also officers of the court.
My lords. Grateful for
Pardon,
that.
item 54, my lord. Earlier dispute, my lord, Justice R.K. Patnaik.
Yeah, Bhavan.
खाली